late we have come long way saying that forgetting that what is the precedent. ಹಂಗಾಗಿದೆ.
ಅಲ್ಲಿ ಅನದರ್ ಆಸ್ಪೆಕ್ಟ್ ಪ್ಲೀಸ್ ಬೇರೆಯವರಿಗೂ ಹಿಂಗಾಗತ್ತೆ ಅಂತಿರಲ್ಲ, ಹಂಗಾಗ್ಬೇಕು ಅಂತೇನೆ. ಅಂದ್ರೆ ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ ಇದ್ರಲ್ಲಿ ನಾವೇನ್ ಮಾಡಿವಿ ಹಂಗಾಗ್ಬೇಕು ನಿಮಗೆ, ಯಾಕೆ ಅದಕ್ಕೆ
ಅಲ್ಲ ತಪ್ಪಿದ್ರೆ ತಪ್ಪು.
ಈಗ ACR
ರೆಕಾರ್ಡ್ಸ್ ವೇರ್
ACR ಅವೈಲೇಬಲ್ ವೇರ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು. Therefore my brother said, why did you take up case of others? You should not have taken up case of others.
ತಪ್ಪಿದೆ ಅವ್ರು ಅಷ್ಟು ಜನದ್ದು 30 ಜನದ್ದು ಇಟ್ ವಾಸ್ ಡೆಫರ್ಡ್, ದಟ್ಸ್ ರಾಂಗ್. ಬಟ್ ಸಮಥಿಂಗ್ ವಿಚ್ ಇಸ್ ಪಾಸ್ಟ್
ಹೋಲ್ಸೇಲ್ ವೇ ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅಲ್ಲೇನೋ ಫೇರ್ನೆಸ್ ಬೇಕಲ್ಲ. ವಿ ಆರ್ ಎ ವೆಲ್ಫೇರ್ ಸ್ಟೇಟ್ ಅಲ್ವಾ? ವೆರಿ ಆಫನ್ ವಿ ಕೋಟ್ ವಿ ಆರ್ ನಾಟ್ ಈಸ್ಟ್ ಇಂಡಿಯಾ ಕಂಪನಿ. This is where it applies. East India Company, yes, they can do anything, but not in a welfare state where the employment is, although it begins with contract, attains status.
Oh,
Tulsi Ram Patel.
He is not at fault, Millards, for whatever it has transpired.
He is not punished him. The other, misconduct, you have punished him. The yet another misconduct, what is that? Absenteeism. ಹಂಗೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಬರಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು, ಬಟ್ ನಾವು ಬರ್ದಿಲ್ಲ. Anyway, we could have written more. We did not write. Anyway, what you have considered, every argument you have advanced.
Please, Millards.
Though not to your satisfaction, but to our satisfaction, we have considered. Sorry.
My lords are satisfied, Millards. That's more than enough. What I could appeal, I have argued.
No, you did well. You argued very well. Well, otherwise, governments generally are destitute at the hands of lawyers, panel counsel, etc. More often than not, they are all they are not taken care of at all, barring very few. Yes.
ಅಲ್ಲ ಒಂದೇ ಒಂದು ಪ್ರೆಸೆಂಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ನಲ್ಲಿ ಅಂತ ಏನಾದ್ರು ಹೇಳ್ಬೋದಾ?
ಅದನ್ನು ಹೇಳಲ್ಲ. You are a very persuasive lawyer. We understand, but ಅದು ಹೇಳಕ್ ಬರಲ್ಲ.
Much up.
Okay. But we appreciate the way he has put forth the matter without wasting time, and very, very pleasantly he has put forth.
True.
Really, we appreciate you, sir. Yes.
The intervention of mediation.
Yeah. Agide.
Completely.
In terms of that,
The only.
It has been accepted in toto as per the report. Unfortunately, the respondent in RFA 1062 could not be present personally.
1062.
How?
ಅವ್ರ ಪರವಾಗಿ ಯಾರಿದ್ರು?
ಅವ್ರ ಪರವಾಗಿ ಅವ್ರ ಸಿಸ್ಟರ್ ಬರ್ತಾರೆ. They are the respondents in another RFA.
ಅವ್ರು agreeable ಇದ್ದಾರಾ?
ಇಲ್ಲ ಇದ್ದಾರೆ ಬೆಂಗಳೂರು, ಅವರಿಬ್ಬರು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾರೆ. This gentleman had to go to America. On 5th he left because of his daughter is suffering from cancer and serious. For that reason, he has made an affidavit.
ಕೊಟ್ಟಾರ?
Affidavit original copy ಕಳಿಸಿದ್ದಾರೆ. ದಯವಿಟ್ಟು ತಾವು ಕೊಡಿ.
ಏನಂತ ಹೇಳ್ತದೆ ಅದು affidavit? We agree with this ಅಂತನಾ?
What I am submitting, same thing he has stated. It has been notarized at Telangana. There's a Hyderabad.
ಅದಾಯ್ತು. We are asking you, what in the affidavit he has stated? Agrees with the settlement?
He has accepted. He has accepted. Kindly see.
The only question is that the original has not come to him.
Original ಅದು ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಂದ್ರೆ ನಾನು 7ವರೆಗೂ ವೇಟ್ ಮಾಡಿದೆ, ಬರ್ಲಿಲ್ಲ.
ಏನು ಒರಿಜಿನಲ್ ರಿಪೋರ್ಟ್?
ಒರಿಜಿನಲ್ ಅಗ್ರಿಮೆಂಟ್
ತಮ್ಮ ಕೈಯಲ್ಲಿ ಅದು
he has sent through the.
Not able to accept then.
ನಾವು ಆನ್ಲೈನ್ ಯಾಕೆ ಇಟ್ಟಿವಿ ಅಂದ್ರೆ ನಾಳೆ ಬೇಕು ಅಂದ್ರೆ ಯಾವಾಗ ಬೇಕು ನೋಡ್ಕೊಳಿಕ್ ಬರ್ತದೆ. ನಾವೇನ್
ನನಗೆ ಈ ಇದ್ರಲ್ಲಿ ಕಳ್ಸಿದ್ರು, ಮೊಬೈಲ್ ಕಳ್ಸಿಕೊಟ್ರು ನನಗೆ. He has sent through the email, this one speed post, ಅವ್ರ ಸಿಸ್ಟರ್ ಹತ್ರ ಕಳ್ಸಿದ್ದಾರೆ. Till 7:30 night I waited.
ಅದಾದ್ಮೇಲೆ ಅದನ್ನ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ. ದಟ್ ಬಿಕಮ್ಸ್
ಅದು ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೆ ತಾವು ಮಂಗಳವಾರ ಮಧ್ಯಾಹ್ನ ಹಾಕಿಸ್ಕೊಡಿ.
ಮತ್ತೆ ಮಂಗಳವಾರ ಎಂತದ್ದು? ಅಲ್ಲ, ಮಂಗಳವಾರನೇ ನಮಗೆ
ಅಲ್ಲ, ಅವರಿಬ್ರು ಇರ್ತಾರೆ ಇಲ್ಲೇನೆ.
ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಕೊಡಕ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ. You are saying
accepted. I have no objection in this.
But all the parties have accepted.
Accepted. There are no dispute. It has been settled amicably.
ಎರಡು ಯಾಕೆ RFA ಇತ್ತು?
ಅದು ಎರಡನೇ
ಇವ್ರು ಹೇಳಿ. appellant.
One the suit for partition which I filed,
Ah,
that was dismissed.
Ah.
Another another suit is they filed for eviction from me from the scheduled property. That was allowed. So against the judgment, common judgment, I filed two.
common judgment. These two appeals arise from a common judgment and decree dated 27 February 2017, entered by the learned 7th Additional City Civil Judge Bangalore, bracketnalli CCS number 19, whereby appellant's OS number 8843 of 2009 having been dismissed, correct? Respondents, our respondents. Respondents OS number 9554 of 2007 came to be decreed. Correct?
Correct.
Kutkoli, you sit down. Sit here only. Sit here so that you can hear our words.
Grateful to my lord.
ಯಾವ ಆರ್ಡರ್ ನಿಂದ ರೆಫರ್ ಆಗಿತ್ತು ಮಿಡಿಯೇಷನ್ಗೆ? ಪಡಿ, ಮಿಡಿಯೇಷನ್ ಆರ್ಡರ್ ಪಡಿ. ಯಾವ ಆರ್ಡರ್, ಬೈ ವಿಚ್ ಆರ್ಡರ್?
Last month.
Last hearing date, Kalyan. (21/9/2024).
ಇವನ್ 9 ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ರಿ ಅಲ್ಲಿ.
ಹಾ,
ಆರ್ಡರ್ ಯಾವತ್ತಾಗಿತ್ತು?
Just-
Coordinate bench. A coordinate bench of this court, wide order dated 38 ಕೊಡ್ರಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Dated 38/2024 had said as under. Full stop. Next paragraph. In terms of the above order, the parties appeared before the mediation center. ಅವತ್ತೇ ಇದ್ರ ಬೇರೆ ದಿವಸನ?
ಬೇರೆ
There.
21/9.
21
21/9 to
or center, and got the list amicably settled in terms of the mediation report ಎಲ್ಲಿದೆ?
memorandum of settlement. 28/10/2020.
In terms of memorandum of settlement,
Date is ಯಾವ್ದು?
28.
sent by the mediation center with a forwarding letter dated 29/10/2024 to the Registrar General of this court. First stop. ಅದನ್ನ ಮೇಲಿನ ಪೇಜ್ ಮೇಲಿನ ಪ್ಯಾರಾಗ್ರಾಫ್ಗೆ ಸೇರಿಸ್ಬಿಡು ಈಗ ಹೇಳಿದ್ದು. ನೆಕ್ಸ್ಟ್ ದಿ ಮೆಮೊರೆಂಡಮ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ filed under section 89 of CPC 89, read with rules 24 and 25 of CPC, read with rules 24 and 25 of the Karnataka Civil Procedure Mediation Rules 2005, is signed by ಯಾರ್ಯಾರು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ?
All the
Appellant
parties.
have
that
not
is,
responded.
All the parties?
All the parties, the appellant as well.
All
as
the parties. First off, it is so asserted by the learned advocates appearing for the parties before us this day. First off. The same, the text of the memorandum of settlement is as under. First off. Next paragraph. Learned counsel appearing for the respondent, ಯಾವ respondent?
ಎಲ್ಲ
Respondents.
ನಾನು appear ಆಗ್ತೀನಿ.
Respondents has passed down to us a copy of affidavit sworn to by
ಕಲಾಕರ್ ಮೂರ್ತಿ.
Sri P.
ಈ ಕಲಾಕರ್
P. Kalakar Murthy, son of late P. Krishnamurthy, who happens to be respondent number?
One respondent number in RFA 1062 of 2017.
One respondent number one in RFA 1062 of 2017 and respondent number
ಇಲ್ಲ ಇಲ್ಲ ಒಂದ್ರಲ್ಲಿ.
ಇಲ್ಲ ಒಂದ್ರಲ್ಲೇ
2017. 17. Seeking exemption from personal presence before this court. First off, the said affidavit has been sworn to Hyderabad ನಲ್ಲಿ swearing ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ ಅಲ್ಲೇ
At Hyderabad, Telangana. Hyderabad, Telangana. First off, the same reads as under. Next paragraph. We have perused the contents of memorandum of settlement and also of the affidavit sworn to by first respondent who has since gone abroad. First off. We have also heard learned advocates appearing before the parties, before the court, who vouch, new signature genuine, who vouch the authenticity of the contents of the settlement and also the signatures which the parties have identified signatures which the parties have put to the document, instrument in which the settlement is drawn. First off, we do not find any reason to doubt the bona fide of the settlement. First off. Nor do we find any factual or legal impediment for accepting the settlement as settling the list between the parties once for all and to make it a rule of the court by setting aside the impugned judgments. Correct? ಇಲ್ಲ ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಅದಕ್ಕೆ ಕೇಳಿದ್ವಿ.
He accept the judgment in toto.
ಯಾರು ಫಸ್ಟ್
The appellant.
respondent.
Appellant accept the judgment in toto. But this Kalakar Murthy will sacrifice, the magnanimously pays 50% of his sale consideration to him.
Embardema, last line. And make it rule of the court by modifying the impugned judgment and decree
Orders modify ಆಗೇ ಇಲ್ಲ.
as it is
As it is accepted. ಅವ್ರಿಗೆ ಮಾನಿಟರಿ ವ್ಯಾಲ್ಯೂ ಬೇಕಿತ್ತು ಅವ್ರಿಗೆ ಅಷ್ಟೇ. ಮಾನಿಟರಿ ವ್ಯಾಲ್ಯೂನ ಅವ್ರಿಗೆ 50% ಅವ್ರಿಗೆ ಬರುತ್ತೆ, ಕಲಾಕಾರ ಮೂರ್ತಿಗೆ ಬರುತ್ತೆ ಆಸ್ ಪರ್ ದ ಡಿಕ್ರಿ. ಅದರಲ್ಲಿ ಅವರಲ್ಲಿ 50% ಅಂದ್ರೆ 25% ಆಫ್ ದ ಓವರ್ ಆಲ್ ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್
ಹೇಳ್ತೀನಿ. ತಾವು ಇದು ಡ್ರಾಫ್ಟ್ ಇದೆ ನನ್ನ ಹತ್ರ, ಇಲ್ಲೇ ಡ್ರಾಫ್ಟ್ ನಲ್ಲಿ ಹೇಳ್ತೀನಿ ನಾನು. ಪ್ಯಾರಾ 4 ದಯವಿಟ್ಟು ತಾವು ನೋಡ್ಬೇಕು. Para 4. This is the correction. What happened?
ಈಗ ಇಂಪ್ರೂವ್ ಜಡ್ಜ್ಮೆಂಟ್ ಜೊತೆ 4 and 5 ಅನ್ನ ಓದ್ಬೇಕಾಗತ್ತನು?
ಹೌದು ಸ್ವಾಮಿ, ಖಂಡಿತ.
ಎರಡೇ.
It should be added to that.
Paragraphs added.
ಹೌದು,
the judgment.
ಯಾಕಂದ್ರೆ I spent 4 days to convince Kalakar Murthy to sacrifice.
We appreciate that. Now answer the question whether these two 4 and 5
ಹೌದು ಸ್ವಾಮಿ.
4, 5, 6.
4, 5, 6.
5 and 6.
6 ಬರುತ್ತೆ. 6 ಮೆಥಡಾಲಜಿ ಬರುತ್ತೆ.
6 ಬರ್ತದೆ.
ಬರುತ್ತೆ.
ಏನ್ ಬರ್ತದಮ್ಮ?
3 ಕೂಡ ದಯವಿಟ್ಟು ಆಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ. 3 ಕೂಡ ಆಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ. Because
by adding,
three,
ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ ಸುಮ್ನೆ. By adding
Huh.
terms of the
Terms of the-
settlement to the judgment.
Grateful to Madam.
ಆಯ್ತು sir.
That clinches the issue.
ಅಲ್ವಾ?
ಆಯ್ತು.
Judgment and decree, impugned judgment and decree. Impugned common judgment and decree. First stop. Ordered accordingly, last thing. And appeals are disposed of. Costs having been made easy. Costs easy again.
Please,
Implement.
my lord,
Court fee ಏನಾರ refund
ಹೌದು.
ಆಗುತ್ತಾನೋ?
ಹೌದು. My request.
The registry to entire court fee ಹೋಗುತ್ತವ?
ಹೌದು, 100%. Before hearing.
ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಂಜುನಾಥ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ?
ಹೌದು, 2020 ಅಲ್ಲ.
Registry to
66C ನಲ್ಲಿ.
refund the entire court fee to the appellant. Registry to refund the court fee to the appellant in accordance with law.
In both the appeals.
In both the appeals, in accordance with law.
My lord, sir, one request, my lord.
Ah.
In they had preferred an execution.
Ah.
In that execution,
Ah.
number 1730 of 2018, I have deposited rupees 6,72,000. That may be also.
ಮಾಡ್ಬೋದು. ಯಾಕಂದ್ರೆ ನಾವು we are withdrawing the
Any amount deposited by the appellants in execution number
1730 of
1730 of
2018
2018 shall also be refunded to the appellant.
grateful.
Interest ಏನಾರ ಬರುತ್ತಾನ ಅಲ್ಲಿ? ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅವರು? ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಾ?
Deposit ಮಾಡಿದೀವಿ, but interest.
ಯಾವುದೇ ಡೆಪಾಸಿಟ್
ಇಲ್ಲ ಸಿಂಪಲ್ ಡೆಪಾಸಿಟ್.
deposit along with the interest if any, without broking delay. Execution ಏನಾಗುತ್ತೆ?
It gets disposed of. They have to be there.
The first respondent,
ಯಾವ್ದು? ಇಲ್ಲ, ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ದಟ್ ಇಸ್
The respondents,
Respondents.
1 and 2 in RFA 106.
1062.
the
ಇಲ್ಲ 1062.
1039.
1039.
103.
the respondents who happen to be the decree holders, respondent numbers
1 and
ಅಲ್ಲಿರೋ
2.
ಇಬ್ರು ಇದ್ದಾರೆ.
1 and 2 in RFA number
1039 of 2017.
1039 of 2017, who being the decree holders has levied execution in execution case number
Okay.
1730 of
1730
of 2018,
2018,
quota number 19,
pending on the file of
CCH number 19.
CCS number 19, agree that the same is be treated as having normally agree tagadu, have withdrawn the execution petition.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಟರ್ಮ್ಸ್ ನಲ್ಲಿ ಇದೆ.
ಒಂದು ನಿಮಿಷ ಅದು ಕ್ಲಿಯರ್ ಮಾಡಬೇಕು. Execution petition in terms of the settlement. And therefore, the same is ordered accordingly.
ಹೌದು.
First off, a copy of this order shall be filed in the executing court by the appellants.
Please, madam.
By the appellants before long. ಈಗ ಕಾಸ್ಟ್ ಮೇಡ್ ಈಸಿ ಅಂತ ಮಾಡ್ತೀವಿ. ಕಾಸ್ಟ್ ಮೇಡ್ ಈಸಿ.
We are grateful, madam.
ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ, ಅದು ಒರಿಜಿನಲ್ ಅಫಿಡವಿಟ್ ಬಂದಾಕ್ಷಣ
ಹೌದು, ಕೊಡ್ರಿ.
That should be filed along with the memo.
the undertaking given by Litigant Counsel appearing for the first
Respondents.
for the respondents, that the original affidavit of the first respondent
ಕಲಾಕರ್ ಮೂರ್ತಿ
shall be filed in the registry
along with the memo.
along with a memo within
ಬಂದ ತಕ್ಷಣ ಕೊಟ್ಬಿಡ್ತೀನಿ
ಅಲ್ಲ,
ಇವತ್ತು.
ಹಂಗೆ
I'm
ಬಂದ ತಕ್ಷಣ
expecting
ನಾವು
today.
Weeks time ಅಂತ
ಈ ST ಬಸ್
ಬಿಕಾಸ್ ನನ್ ಕಂಟ್ರೋಲ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು, ಅದರಿಂದ
Weeks
ಅಷ್ಟೇ.
time ಅಂತ ಹೇಳಿ.
within 2 weeks.
ಆಯ್ತಾ, ಖಂಡಿತ
Within
ಬರುತ್ತೆ.
2 weeks, and that the registry shall place it as a part of record of the case.
Please, madam.
Okay.
Nagaraj.
Ah. Yes, Deepak ಏನಿದು?
ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಹಾ.
ಇದು ಇಟ್ಸ್ ಅ ಕಂಪನಿ ವಿಚ್ ವಾಸ್ ವೌಂಡ್ ಅಪ್. ದಟ್ ಕಂಪನಿ ವಾಸ್ ಇನ್ಕಾರ್ಪೊರೇಟೆಡ್ ಇನ್ ಟೆಕ್ಸಸ್, ಬಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ದೇ ಶಿಫ್ಟೆಡ್ ಟು ಜರ್ಮನಿ. ಸೊ ಐ ಹ್ಯಾಡ್ ಟೇಕನ್ ಥ್ರೂ RPAD. I have an ಇದು notification from the online notification that he has been served. I may be permitted to file a memo of service.
ಅಲ್ಲ ಅದು ಸರ್ವಿಸ್ ಅಂದ್ರೆ CPC ಆಗತ್ತನೋ?
ಅದು normally it is CPC.
CPC ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಪ್ರೊಸೀಜರ್ ಇದೆ.
Please.
ಹಿಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ
Order 5.
ಅಲ್ಲಿ ಲಾಂಗ್ ಪ್ರೊಸೀಜರ್ ಇದೆ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ we have taken the service through this court itself.
ಕರೆಕ್ಟ್.
Court RPAD, through RPAD.
ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದೆ. RPAD ಇಂದ ತಗೊಳಕ್ ಬರಲ್ಲ. These documents should be submitted to the Ministry for Foreign Affairs. ಅವ್ರು ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು they will take a decision.
That
Whether
I'm not aware.
Ah.
I'll have to look into it.
ಇದೆ ನೋಡ್ಕೊಂಬನ್ನಿ.
But ಇದು
ನೋಡಿದ ತಕ್ಷಣ ಅನಿಸ್ತು. Bench also perhaps it was not aware of that.
Yes, they directed
Just
me to
examine
take-
ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, yes.
Examine ಮಾಡಿ.
Because now he has shifted from USA to Germany.
Germany. ಆಯ್ತು.
So
ಅವಾಗ
somehow we could locate, but a winding up order was issued, but that's been stayed. He is nowhere and he was required to deposit 25 lakhs. That also has not been done.
ವೆರಿಫೈ ಮಾಡ್ಕೊಂಬನ್ನಿ. ಅದ್ರ ಮೇಲೆ I have also written one judgment.
I'll just
ನಾನೊಂದು
look into
ಬರ್ದೇನಿ, ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಇನ್ನೊಂದು ಬರ್ದಾರೆ. ಸರಿ ನೋಡ್ಕೊಳ್ಳಿ.
it. Not.
ಆ ರೀತಿ ಮಾಡಬೇಕು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನಾಳೆ ಅವ್ರಿಗೊಂದು ರಿಕಾಲಿಂಗ್ ಹಾಕಿ ರಿಕಾಲ್ ಮಾಡಬೇಕಾಗತ್ತೆ ಅದಕ್ಕೆ. ಓಕೆ. 2 weeks.
2 weeks.
2 weeks. That's the request of course. Next. Simple ಇಲ್ಲ ಅದು. Company, especially EDT companies ಎಲ್ಲ ಇದ್ದಾಗ it has to go to the service should be through the consulate. Yes.
My lord, we'll comply with the office objection, my lord, in week's time may be granted. One-
ಹಿಂಗೆ ಮುಂದೆ
ಇಲ್ಲ, ಇಲ್ಲ,
ಏನದು
only-
ಅಬ್ಜೆಕ್ಷನ್?
Only in respect of producing,
ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಮುಂದೇನು ಆರ್ಗ್ಯೂ?
we got ready, my lord, we have prepared it. We'll file it with, we'll comply with the
ಏನು
office.
ವೈ ಕಂಪ್ಲೈ? ನಾವು ಬಿಟ್ಟು ಬೇಡ ಬೇಡ ಅಂದ್ಬಿಟ್ಟೇವಿ ಈಗ.
ಬೇಕಾದಾಗ ಮುಂದೆ ಕೊಡಿ.
ಅವ್ರು ಬೇಕಾದ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಫಾರ್ ದ ಟೈಮ್ ಬಿಂಗ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್. ಏನು
My lord,
ಮ್ಯಾಟರ್?
kindly it may be passed over, my lord.
ಅಸೋರ್ ಏನು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಹೇಳು, ಆಮೇಲೆ ನಾವು ನಿಮ್ಗೆ ತೊಂದರೆ ಬಂದ್ರೆ ವಿಲ್ ಕಮ್ ಟು ಯುವರ್ ರೆಸ್ಕ್ಯೂ. ಸಪೋಸ್ ಏನೋ ಅಲೋ ಮಾಡಂಗಿದ್ರೆ
ಇಲ್ಲ, ಇದು ಟ್ರಾನ್ಸ್ಲೇಷನ್, ಇದು ಕಂಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ
ಏನಿದು?
ಫೈಲ್ಸ್ ಎಲ್ಲ
ಏನಿದು ಅಪೀಲ ಪಿಟಿಷನ್ ಏನಿದು?
ಅಪೀಲ್, SKT
Appeal.
matter, my lord, from the
Appeal.
appeal from the writ petition, my lord, challenging the order
Petition.
passed by KSAT, we have preferred the writ
ಏನದು
petition.
ಆರ್ಡರ್ ಏನಂತ ಮಾಡಿತ್ತು ಕೋರ್ಟ್ ಇದು?
My lord,
tribunal
it is in respect of,
ಹಾ. ಈಗ
Petition, my
ಯು
lord.
ಸಿಟ್ ಹಿಯರ್ ಅಂಡ್ ರೀಡ್.
yes,
ಪಾಸ್ವರ್ಡ್.
Page 2.
Read. Yes. The youngsters ಓದೋದೇನು? We used to treat it as a grand opportunity whenever our senior was not there. You only have to argue, not your senior. Sit down here, full read, enter, make notes and tell us.
Lord, there are some small office objections, Lord,
Yes.
Lord, there are some small office objections, Lord,
Then
I'll
it-
comply with it. But Lord,
Verifying affidavit file ಮಾಡಕ?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಒಂದು ವಕಾಲತ್ತಲ್ ಸಿಗ್ನೇಚರ್ ಕೆಲವು ಕೊಲೀಗ್ಸ್
Compliance within 2 weeks. Okay.
Lord, can I make one
100%.
request, Lord?
Ah.
Can I request, Lord, any day next week, Lord? In fact, Lord, this is a short issue. On my probate petition, Lord, has been rejected by the learned single judge by invoking Order 7, Rule 11 on the ground of limitation.
Rule 11 on the ground of limitation. Limitation ಇದೆಯಾ ಅದಕ್ಕೆ probate?
Parala, that is my primary contention. And also, Lord, my Lord's full bench decision says, Lord, it should be as far as practical, Lord, CPC is applicable.
I think I wrote that judgment.
Yes, Lord. Lords have written that judgment. I had relied upon that judgment. But learned single judge says, Lord, relies upon Allahabad High Court judgment.
I think Allahabad also I referred to, na?
But that is referred to say that, Lord, their rejection of plaint was allowed.
When probate proceeding is contested, it shall be tried as far as possible as a suit. Therefore, it is not a suit.
True.
If it is not a suit, because suit under CPC is not defined, but section 25 says a suit is instituted by the presentation of the plaint. Therefore, anything, any proceeding which is not instituted by presentation of the plaint is not a suit of the whole ಮಾಡಿ. Court fee is not payable ಅಂತ hold ಮಾಡಿದೆ full bench. I wrote that myself.
Yes, yes, my lord.
Justice
So we can-
Veerappa and
The Lordships and Lord Justice Narendra Prasad.
Narendra Prasad. I remember that.
The trappings of the suit.
Trappings
Yes,
of the
my
suit
lord.
and
Yes,
all.
yes.
Therefore, that the end product will not be a decree. ಅಂತನೂ hold ಮಾಡಿಬಿಟ್ಟು, you know. We consider two judgments,
Yes.
division bench judgments
ಹೌದು,
of
ಹೌದು.
our high court itself.
Lord,
All. ಯಾವತ್ತು?
Lord, next Friday, my lord.
Friday ನಾವು ಜೊತೆಗಿರಲ್ಲ. We part ways with my brother.
Very well. Lords, may I have it,
We
Lord,
part
on
ways on Friday.
13th or 14th,
I will
subject to Lord's.
attend another great judge of this court, Dr. Prasanna. on
Very well,
Friday.
Lords, I'm sorry. 13th or 14th, subject to Lord's convenience.
ಯಾವ್ದು ಹಾಕಿ. ಅಷ್ಟೇ ಪಾಯಿಂಟಾ?
ಅಷ್ಟೇ ಇರೋದು ಪಾಯಿಂಟ್ ಅಷ್ಟೇ.
28.
ಅಲ್ಲ.
ಯಾ.
13th or 14th, Lord.
ಯಾಕೆ ಏನು ಅರ್ಜೆನ್ಸಿ? ಒಂದ್ ವಾರದಲ್ಲಿ ಏನಾಗ್ತದೆ?
ಅಲ್ಲಿ ಏನ್ ಆಗದೆ ಅಂತಲ್ಲ.
14th ಹಾಕಿ.
14th, grateful.
Half day.
ಅಲ್ಲ, it will not take much time, Lord.
5 minutes.
Lord,
All.
one more indulgence, Lord. My
Huh?
learned friend has filed, Nagaraj has filed caveat, Lord, for one of the respondents.
ಇಲ್ಲ. 14th is Thursday. Thursday. All.
Lord, my learned friend, Mr. Nagaraj has filed caveat for one of the respondent. He appeared for everyone. Lords, may permit me to serve him for all the respondents.
The appellant, appellant is permitted to serve
ಹೌದು.
copy of the appeal memo along with all documents on
D. Nagaraj.
D. Nagaraj Learned Counsel appearing, who appeared
Please,
for rest of the respondents.
please.
In addition to the caveator herein, in the first appeal, another,
ಅದು TOS 1 of 2023.
in COS,
TOS,
TOS, another.
Testamentary Original Suit.
Testamentary original suit, TO, yes, 1 of
23, Lord.
2023.
Grateful.
ಹಾ.
paid today, my lord, sorry.
ಪೇ ಮಾಡಿಲ್ಲ?
ಮಾಡಿ.
Compliance reported, registry to verify. Entry mode to continue. All right. 6. Anil Kalgi. ಏನಿದು ಅನಿಲ್?
The main objection is about the maintainability
ಹಾ, ಏನು ಚಾಲೆಂಜ್ ಮಾಡಿರಿ ನೀವು?
because a writ appeal where 564 and a writ petition 25528 of 2023 have been passed against an unregistered association. Now, unregistered association cannot be
Not
sued.
parties.
No, we are not being made a party. I'm an unregistered, yes.
Said that, na? 64 Supreme Court, ಯಾವುದು?
Dev Singh versus. State of
Shivdev Singh
Punjab.
versus White.
I'll give a copy, sir.
The office objection as to maintainability of the petition is overruled in the light of Apex Court decision in Shivdev Singh versus
State of Punjab.
State of Punjab, AR 1964 AC. 63 no 64?
1958.
58, cannot,
Yes, 265 of 1950.
cannot be 58, na? Cannot be 58. What do you have? 64. 63. 63.
Okay,
Three.
date.
ಮತ್ತೆ ನಮ್ಗೆ
Judgment.
ನಾವೇನ್ ಅನ್ಕೋಬೇಕು? ಇನ್ನೊಂದ್ ಕೇಸ್ ಇದೆಯಾ ಅಂತದ್ದು ಅಂತ.
Appeal number I see.
ಹಾಲ್. ಏನಿದು ಮುಂದೇನು? Objection overrule ಆಯ್ತು. That will not add merits to the case. What are the merits of the matter?
Sir, my project is actually registered under, and there are some other objections I will meet, I will comply with that.
ಹೀಗೆ ಮಾಡ್ಬೇಕು. Supreme Court said review ಅಂತ treat ಮಾಡ್ಬೇಕು.
I'll comply with those other objections.
ಹಾ,
100 rupees fee has to be paid.
All.
And then something which has been wrongly
All
paid,
right.
that will be done.
Office objection to be complied. Suppose in big jurisdiction between A and B, some order is passed that would cast a shadow on C. C was not a part of that. There, two views it. One, you can seek recall of the order, recall of the order with leave of the court. ಇನ್ನೊಂದು ಏನ್ ಮಾಡಿದ್ರು ಕೆಲವು ಕಡೆ ರಿಕಾಲ್ ಕೊಡ್ತಿದ್ರು ರಿಕಾಲ್ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ. Therefore Supreme Court said they can file another writ petition, separate writ petition, seeking review of the judgment. That review is not 47 review. Order 47 review, a bit different review. Yes. All right. ನೀವು ಯಾರಿಗೆ appear ಆಗ್ತೀರಿ?
Government.
Learned AGA is requested to accept notice. ಅಲ್ಲ, ಅದು ಮಾಡ್ಕೊಂಬರ್ರಿ, please, ಅಲ್ಲ, comply ಮಾಡಿ.
Yes.
Respondent number 1 to 5 in the first matter and my lords, cross appellant in the my lords.
Raise for 1 week time, my lord. Actually,
ಏನ್
we have to
ರಜೆ?
prepare.
The partition suit, my lords,
Partition suit.
partition suit came to be my lords decreed in part as against my lords refusal to grant my lords partition in
For
respect
rest
of
of the property.
some of the properties I am before my lords in cross appeal. They are challenging the decree granted by the trial court.
They are challenging the decree of partition.
Partition, my lords,
You are challenging non-grant. of
non-granting
decree.
of a portion of. My lords, there are my lords,
ಹಾ?
death ಎಲ್ಲ ಆಗಿದೆ.
ಯಾವ್ಯಾವ ಅಪ್ಲಿಕೇಶನ್ಸ್? ಏನದು?
ಅದರಲ್ಲಿ
ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? ನೋಡಮ್ಮ. A set of applications have been filed. Semicolon. A few seek condonation of delay in filing the LR applications. Semicolon. The others have been filed
ಏನಾಗಿದೆ?
seeking an order for setting aside abatement of the proceedings. First, the principal applications seek leave of the court to bring LRs of the deceased.
75, 63, 29, 25.
Person, so and so, respondent, so and so, so and so. First, all they have been supported by the affidavit. First, by individual affidavits. First, the respondents who were sought to be brought on record as LRs of the deceased, comma, having been served, have chosen to remain unrepresented. Ellaruna? Except respondent number 75. First stop. Applications of the kind are generally favored as a matter of course, and no exception is made out before us to the same. First, next part. In view of the above, all these applications are allowed. Semicolon. Delay in filing the principal applications is condoned. First off, abatement of the proceedings is set at naught. First off, LRs of the deceased respondents so and so are permitted to be brought on record. First off, appellants to ಯಾವ್ದ್ರಲ್ಲಿ
ಇಲ್ಲ, first
matter.
first matter.
Appellants in first matter RFA so and so to amend the cost title within 2 weeks
29
and further
ಅದರಲ್ಲಿ
file the amended cost title. ಎರಡು ಮಾಡ್ಬೇಕಾಗ್ತದೆ CPC ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಬೇಕು, amended cost title ಹಾಕ್ಬೇಕು. Yes. ಮಾಡ್ಬೇಕಂದ್ರೆ ಬೇರೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಆಗ್ತದ ಅದಕ್ಕೆ.
7.1 ಅಲ್ಲಿ
ಏನದು? ಹಾಕೊಳ್ಳಿ. ಅದರಲ್ಲಿ 3 ಇದಾವನು ಅಪ್ಲಿಕೇಶನ್?
ಅದರಲ್ಲಿ
ಡಿಲೇ ಅಂಡ್
ಇಲ್ಲ ಡಿಲೇ ಇಲ್ಲ ಅದ್ರ
ಒನ್ ಏನು waiting for
ಅದು
ಓಕೆ
May I make one
Application in IA number 19 of 2018, supported by the affidavit, seeks permission to bring LRs of the deceased appellant number 2,
Yes,
bracket nalli A to C, Allah. Appellant number 2
to A to C.
on record. Full stop. ನೀವೇನು ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಹಾಕಿಲ್ಲ ಅದಕ್ಕೆ ಯಾರಿಗೆ ಪೇರ್ ಹಾಕ್ತೀರಿ? Though the first respondent who is represented and other respondents who have been duly served with the court notice have not chosen to file any objections to the said application. Full stop. Applications of the kind, comma, as already mentioned above, are to be allowed as a matter of course in the absence of any derogatory circumstances. First stop. Next, in the above circumstances, the subject application having been favored, LRs of deceased appellant number 2 are permitted to be brought on record to represent his estate. First, appellant to amend the cost title and also file an amended cost title as well.
Yes.
Within 2 weeks.
Yes. Okay. May I make one more request, my lords? Insofar as serial number 3 is concerned, my lords, in 7.1.
Serial number 3.
Memo reporting the death of respondent number 61 is concerned. Lords, by an order dated 18/6/2018, notice to our the respondent number 61 was dispensed with, my lords.
Dispensed
Dispensed with.
ಈಗ ಪ್ರಶ್ನೆ ಬರಲ್ಲ ಅಂತ.
ಈಗ ಅದರ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. Anyway, I have reported the death, my lords, but
ಅವ್ರಿಗೆ LRs ಇಲ್ಲನು?
LRs, I will seek instructions. my lords. I'll
ಮಾಡ್ಬೇಕು
seek
instruction.
I'll seek.
Only the CPC 1976 amendment to order 22.
My lords, in the memo itself, I have stated that he died in without any, my lords, LRs.
You have said that.
Yes, my lords, in my
Then in
memo.
terms of that, we'll dispense with
Yes,
ಅವಾಗ representation ಪ್ರಶ್ನೆ
ಬರಲ್ಲ.
ಬರೋದಿಲ್ಲ.
my memo state, my lords, died issueless and leaving behind no legal representatives.
ಅಲ್ಲಿ dispense ಮಾಡೋದು when he is alive. If he is not alive, Justice Nisargi says, dispense notice can be dispensed with if the respondent is alive.
Alive.
If the respondent is dead,
Yes.
no questions.
When he was alive, my lords, I sought for dispensation. Now, my lords, he is no
ಅಲ್ಲಿ
more
ಬರ್ಕೊಳ್ಳೋಣ, ಇನ್ನೊಂದು.
and died issueless.
Subnet counsel, Mr. S. Rajashekar, appearing for the appellants, points out, appellants in RFA crop points out that respondent number
61, my lords.
61 having died issueless and he has no LRs.
Yes.
Even otherwise.
Yes.
Comma, the question of bringing the LRs would not arise. ಯಾವುದು order 22 rule? ಯಾವುದು CPC?
Three or four.
Three or
Three and four, madam. Three is the plaintiff, not the four is the defendant.
ಅಲ್ಲ, this is where party has no legal representatives.
7.
ಅನ್ಕೊಂಡು ಒಂದು separate amendment ಆಗಿದೆ.
7.
ಅಂತ ಹೇಳ್ಬೇಕು, ನಮಗೂ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ನಾಳೆ ಯಾರು ಇನ್ಸ್ಟೆನ್ಸ್ ನಮ್ಗೆ ಕೇಳಿದ್ರೆ ಏನ್ ಹೇಳ್ಬೇಕು ನಾವು? Wide order 22 rule so and so ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Yes.
Sorry, ನಮಗೂ ಸ್ವಲ್ಪ ಹೇಳಿ ಹಾಗೆ. We'll also learn.
One more request, my lords, insofar as, my lords, steps to be taken in respect of deceased are 25, that is at serial number 1, my lords.
In ನೋಡಮ್ಮ, in RFA ಅದು crop ಅಲ್ಲ, crop neutrally.
Nandralli.
In RFA crop,
To be taken in
steps to be taken in respect of respondent number,
deceased respondent number 25 on
this is respondent number
25.
25.
Now, my lords, my respectful submission is in the connected, in the main appeal, my lords. The respondent number 25 is died as respondent number 29. And his legal representatives are already brought on record. But now,
ಮೆಮೊ ಕೊಡಿ.
yes, please.
ಮತ್ತೊಂದ್ಸರಿ ಯಾಕೆ ಬರ್ಬೇಕು? ಮೋಶಿವಣ್ಣ ಮೆಮೊ ಕೊಡಿ. ಅಲ್ಲಿ ನೋಡಮ್ಮ. Learned counsel appearing for the appellants in RFA crop submits has filed a memo to the effect that the LRs of respondent number 29 happen to be
LRs.
the LRs of deceased 29 in companion RFA number
1189 of 2016.
so and so happen to be LRs of deceased respondent number 25
In
in
crop.
this appeal. Yeah, herein. hearing. And therefore, the estate of the deceased is represented in the subject matter. And therefore, formal application for bringing those LRs again on record be dispensed with, treating the said LRs as having brought up in this matter. First off, we agree with this. Okay.
Great.
A note to be filed to this effect beside the cost item.
Please.
Not money, not to be made. All.
Since it is a suit for partition, not may be taken up, not any.
2016. ಈಗ 13 ತೊಳ್ತಾ ಇದ್ದೇವೆ ನಾವು ನಿಮಗೆ. Mostly if bench continues in January or February, we will take up these matters. Yes.
Representing the
Sorry.
in the matter.
I appear for the petitioner. Not short point involved, not this arises out of a consumer dispute. Whether proof without pleadings can be permitted is a question, my lords.
Proof without pleadings.
Without pleadings,
That is a strict rule of evidence and pleadings
please.
in good olden days. If both the parties have understood each other's case, absence of pleading will pale into insignificance is the law now declared by the apex. Not now, mostly
Please.
before you were born.
Lords.
I think 1968, 69 ನಲ್ಲಿ there.
What has-
Amandu, secondly, so Consumer Protection Act ತೆಗಿರಿ. Evidence Act is not applicable ಅಂತೇನೋ ಮಾಡಿದಾರಲ್ಲ.
No, indeed. No, what has actually happened here is, my lords, now 45 days is the maximum time which is permitted for the opposite party to file their version.
Correct.
Now, after the expiry of 45 days, the version is filed.
Yeah.
The consumer forum holds that the version cannot be taken on record. Now, against that order, my lords, a review is preferred. A revision is preferred before the Karnataka State Consumer Disputes Redressal
Okay.
Commission, KCDRC, my lords.
That is pending or rejected?
Sorry, I'm
No,
sorry.
that is
I
KC.
had filed a review application before the same forum, which was allowed. Thereafter, I went before the,
ಅಲ್ಲೇನಾ?
thereafter, my lord,
Application was,
you-
review
you
application
file a-
was filed by me.
yes.
No, review application is a different issue. Now, for all purposes, as against that order, my lords, a revision was preferred before KCDRC. There, KCDRC holds that there is no fault with the order of the District Consumer Forum. However,
Order of the District Consumer Forum saying
saying that after a period of
filed belatedly can be accepted.
cannot be accepted
Cannot be accepted.
and finds no fault with it. Finds no fault with it. But however, and dismisses the revision. And however, it makes an observation stating that in such circumstances, we are of the view, no scope to revise the order dated so-and-so in exercise of powers under so-and-so. Accordingly, the revision petition is hereby dismissed with an observation. OP is at liberty to submit affidavit evidence along with documents, if any, in the complaint case to enable the DCDRC to appreciate materials placed on record by the complainant. This is the observation which is made.
Assume that he has not filed WS in a suit.
Please, my lords.
Is he not entitled to lead evidence?
My lords, on probably on questions of law, my lords, he may lead so. I have no difficulty with that. But can, in the absence of pleadings, can evidence be led?
That you can argue when matter is taken up. What has happened now?
My lords, the matter is pending.
Then why you argue that? Whatever evidence, how that is done? Whatever generally, the general principle is evidence sans plea is no evidence, cannot be taken cognizance. Many exceptions are there to that rule. Okay. That you can take up when the matter is argued after leading the evidence. Why to interdict? How you know what is pleaded, what is not pleaded, what should be treated, all these things. How the commission will treat it, how you know?
No, my lords, my respectful submission to this.
Okay.
May I make one submission in this?
Yes.
The Consumer Protection Act categorically states
Correct.
that after a period of 45 days, the version cannot be taken on record.
Correct.
Now, so therefore, my lords, in effect, the version does not exist.
You can argue all this after the evidence is led. See, Justice Kumar has said, even in the absence of filing of WS, it is open to the other side to lead evidence and to cross-examine also, but scope will be limited. That
Cross-examination.
you can examine when you argue the matter. You take up all these contentions when the main matter is taken up after leading of the evidence.
There's one judgment of the NCDRC, my lords, which says on this point that once the written statement or version is not taken on record, the question of leading evidence would also not.
No, we don't agree with that.
My lords, I will place it on record, my lords. My lords,
That does not lay down the law. Where is the, which section says they have capacity to lay down the law? Only High Court and Supreme Court alone can lay down.
indeed,
law.
my lords, even there's one judgment of the Supreme Court also,
Badi,
which says, I'm sorry, my lords, I'm not getting.
help that. Barkali.
Let me place it on
No, no,
record. My lords,
we
I kindly
will not
pass it
give the-
over.
We never do things in installments. Barkali.
My lords, pass it over. I will produce that
No,
judgment.
No, the thing, you have said that you have come without instruments, you have come without the weapons to the battlefield. Therefore, whatever happens, happens to you. The petition, Kutwali, please be seated, you have argued. Petition seeks to call in, this petition filed under Article 226 and 227 of the Constitution of India calls in question the Karnataka State Consumer Dispute Redressal Commission's order dated 7/6/2024.
Sorry, may I make one submission? Notes. This order is an ex parte order which has been passed without even notice to me. No, I'm just making that submission.
Whereby the revision petition filed by the petitioner has been negatived, filed by the petitioner
Please, please.
has been negatived. First, next paragraph. Learned counsel, ಕುತ್ಕೊಂಡೆ ಉತ್ತರ ಕೊಡಿ. ಇದೇನು ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಅಲ್ಲ ಎಂತದಲ್ಲ, ಕುತ್ಕೊಂಡೆ ಉತ್ತರ ಕೊಡಿ. ರೆಸ್ಪೆಕ್ಟ್ಫುಲಿ ಕೊಟ್ರ ಆಯ್ತಪ್ಪ. ನಾವು ನಿಮ್ ರೆಸ್ಪೆಕ್ಟ್ಫುಲಿ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು, ನೀವು ನಮ್ಮನ್ನ ರೆಸ್ಪೆಕ್ಟ್ಫುಲಿ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ. ಎದ್ದು ನಿಂತ್ಕೊಂಡು ಕೊಡೋ ಅಗತ್ಯ ಇಲ್ಲ. ನಾಟ್ ಎ ಪ್ರೈಮರಿ ಸ್ಕೂಲ್. The learned counsel for the petitioner vehemently argues that in the complaint in question, the time-barred pleadings of the other side having been so treated, comma, the question of leading evidence from his side would not have arisen, comma, the long-standing legal position being that no evidence sans plea. First, learned counsel appearing for the respondents resist the petition, contending that the rule that no evidence sans plea has many reflections and shadows, shades, and therefore it cannot be chanted like a mantra in every case. Full stop. He further submits that even in the absence of filing WS in a suit, comma, defendants are entitled to lead their evidence and evidence by way of examination in chief or by cross-examination of the witnesses of the other side, comma, although its scope is restrictive. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made on behalf of the respondents herein. Full stop. That apart, whether evidence can be led in the absence of plea and plea can even otherwise be argued by the petitioner when the matter is taken up for hearing at the hands of district forum another. District forum. First, therefore, the petition is premature and preposterous. Preposterous. First, next paragraph. In the above circumstances, the petition is disposed of with the above observations, keeping open the contentions taken up in this petition for being urged in the complaint. Okay, when it is taken up for hearing.
One request, my lords. Restrictive, my lords have indicated that it is very restrictive to law anta, if my lords may say, because otherwise, if facts are interjected, then it becomes.
ಅಲ್ಲಿ ಮಾಡಿ.
Let that one word be added is all my humble request. Restrictive, the evidence is restrictive to the extent of the law involved.
ಅದನ್ನ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು. Next. No cause. ಯಾವಾಗಿಂದ ಕಂಪ್ಲೇಂಟ್?
Complaint is of the year 2023.
23.
20, please, my lords. 23. 23, my lords.
ಹಾ.
Lord, in this case, I am retiring, my lord. Learned Deputy Solicitor General has been nominated, renominated.
Shri Desai is permitted to retire, and in his place, Shanti Bhushan, learned DSG, appears for the petitioner.
Yes,
Correct, huh?
yes, ma'am.
Petitioner. Okay.
I will hand over the file, my lord. Still I have.
Buddy,
Please.
the council to hand over the file to the DSG immediately. Yes. Well.
Time may be granted.
ಯಾವ್ದಕ್ಕೆ? Immediately ಕೊಡಬೇಕು. Section ಹಂಗಿದೆ law. Next.
No, file I will hand over, my lord, but today.
Next. That's the law. You are not entitled to retain. You have seen even right of lien also is killed by the apex court in famous judgment. Yes.
Lord, the issue is of compassionate appointment.
Yes,
There is
but-
a long history of several rounds before the Central Administrative Tribunal. Would your lordship please have a look at the order at page 72. Lord, the order of the tribunal dated 3rd January 2014. This was the
ಯಾರು respondent ಯಾರು? ಅವ್ರು ಬರ್ಲಿ. For this matter in the second week of January 2025. Entry ಮಾಡಿದೆ ಏನು?
Lord, we made this up for till for the order.
ಇದೆಯಾ?
It was interim, there is interim order.
correct.
Lord, appear for the petitioner in this case, my lord.
Hmm.
The short question, my lord. In the case of selection of motor vehicles inspectors, the tribunal directed the KPSC to consider the second medical report given by the board, my lords. Second medical test report. The first one, they declared as ineligible. Later on, they have declared as eligible. And this honorable court on 28/7/2023, my lord, measured the height of the respondent before this honorable court, and it was 162 centimeters, and required is 168, my lord. Hence, I request on this ground, my lord, since the height is not in the, as per the terms and conditions of the notification.
Height is less than the prescribed.
Yes, my lord. The page number, my lord, the notification, the terms and conditions, at page number, my lord, 56.
All right, you said 58 cm ಇರಬೇಕು ಅಂತನಾ?
168 centimeters ಇರ್ಬೇಕು ಸ್ವಾಮಿ.
Cm
162 ಇದ್ದಾರೆ.
162 ಇದ್ದಾರೆ. ನಿಜನಾ?
ಹೌದು. Lord, as far as height is concerned, my lord, there is no dispute. In the re-medical test, I am, my lord, treated as, my lord, eligible. Notwithstanding that, my lord, this honorable court has directed me to appear. My lord, I was asked to appear in person, my lord. The measurement was taken in the open court and it was 162.
How you are eligible?
Lord, the matter is, my lord, fully covered by the coordinate bench judgment,
But
lord, which is at
ಆ height ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತ
height ಅವಶ್ಯಕತೆ. Lord, the central legislation, Lord, 254 repugnancy comes. Lord, in the central,
overrides the state rules antana.
in respect of motor vehicle inspector selection itself. Lord, may I request my lords to kindly take the memo dated 26/9/2024, which I have filed. Lord, page 12 is the coordinate bench judgment. Relying upon, my lord, the Honorable Apex Court's interim order.
ಅಲ್ಲ ನಾ ಎರಡಕ್ಕೆ ಎರಡು ಒಂದೇನಾ?
Lord, page 12.
Where do you stand?
My lord.
Page 12.
Page 12. Lord, it is contended. Page 16, my lord. Page 12 it starts. Page 16, para 6. Learned counsel for the.
Is contended.
Sorry. Para 8, my lord, having considered the contentions
As per
advanced.
the requirements for direct recruitment, petitioner's case cannot be differently dealt with by the state.
Yes, this is direct recruitment, my lord. In the case where my lords are reading the order, is promotion. Lord, requirement of height, yeah, for
Is
direct.
As per the direct recruitment.
As per the direct recruitment. That fell for consideration before this honorable court. This honorable court directed that my lord consider the case for appointment, not with,
As if they are direct recruitment candidates. That's all.
and without reference to the height.
Height prescribed being 168 cms. So far as that candidates in the direct recruitment is concerned, applies to your claims. Therefore, even if it is short of 168 cms, you cannot be disqualified. And stem with the case.
One submission, sir.
Yes.
My lordship permits. I request my lordship to take this order was passed by the coordinate bench based on the interim order passed by the Apex Court.
Correct.
In 2006 motor vehicle inspectors batch, my lord.
Correct.
Therein it was held that subject to the page number 3 and 4, my lord.
Correct. Subject to outcome of that.
Yes, my lord.
Correct.
Here, my lord, the
Outcome ಏನಾಯ್ತು?
ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ ಅದು.
ಅದನ್ನೇ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ನಾವು.
ಅಲ್ಲ, if my lordship permits.
What permits? You have said we have agreed.
My lord. Yes,
You have said we have agreed. Still you want to argue?
No, my lord. No, it's not like my lord. My humble submission to my lordship says, the Apex Court repeatedly held, being a selecting authority, we don't have any power to relax the terms and conditions of the notification. And that the facts and circumstances relates to the 2006 batch is different from the case in hand is 2016 batch, my lord.
Correct.
We cannot relax the terms and conditions.
Correct.
And it
Coordinate
violates-
bench has said like this, it binds us. How can we differ from the coordinate bench?
that is for promotion ಅಂತ ಹೇಳಿ coordinate bench ಅಲ್ಲಿ ಡೆಫರ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಬೆಂಚ್ ಅಲ್ಲಿ my learned friend I think
No. Coordinate bench says the prescription of height for direct recruitment shall be applicable to claims of Mr. Satish. Para 8. And that is in the light of Supreme Court decision. Why Supreme Court said that is motor vehicles is a concurrent list matter.
Yes,
Center can make law, state can make law. Where center has already made the rules, those rules will override the rules of the state. Our principle, ma'am.
That's true, my lord.
254(2)
Yes,
of
ma'am.
Constitution.
Without challenging the notification, terms and conditions of the notification, they have participated in the selection process.
Correct.
And it is not open for them to rise that ground now. That's
No, not question raising at all.
Yes, ma'am.
Your condition that.
That itself, ಅವರು
ಇವತ್ತು
raise
notification
ಮಾಡ್ತಾನೆ ಇಲ್ಲ.
condition.
ಲಾ ಯಾವುದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ನಿಮ್ಮ
ಹೇಳಿ.
notification ನ condition ಏನಿದೆ 168, that itself is repugnant to the central
ಅಂತ.
rules.
Therefore it has to
How
be.
it will sustain?
In Taluj,
Yes, ma'am.
in Taluj, the Supreme Court considered this aspect of the matter. In respect of items in the concurrent list, central rules, state rules. If there is conflict between these two, the central rule should go.
Prevails.
That they should override the state rules.
Yes, that will prevail.
Our principal amendment. Only thing is, there is one safety for you. All that will be subject to outcome of appeal before the Supreme Court.
Also,
What you say is, when matter is pending before the Supreme Court, the coordinate bench should not have made it. That appears to be sensible. But what we are bound by a coordinate bench.
ಅದ್ರ ಜೊತೆಗೆ ಒಂದೇ ಒಂದು ಲಾರ್ಡ್ಶಿಪ್ ಪರ್ಮಿಟ್
It is still pending.
Brother, my
Either
learned friend is right. Kindly come to the page 18 in the memo. But the coordinate bench has considered this
Aspect also.
also and my lord, page 18 my lord. ಆ ಲಿಬರ್ಟಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. My learned friend has seen that accordingly this writ petition is disposed of, directing that the petitioner shall also be granted promotion.
Shall be provisional.
ಅದು ಪ್ರಮೋಷನಲ್ ಸ್ವಾಮಿ. ಇದು DRL ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಇಂಥವ್ರು ಮತ್ತೆ ಹೋಗಿದ್ದವರೆಲ್ಲ ಮತ್ತೆ ಬರ್ತಾರೆ ಹಾಕೊಂಡು ಪಂಡ್ರಾ ಬಾಕ್ಸ್ ವಿಲ್ ಓಪನ್.
ಅವರಿಗೆಲ್ಲ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ನಾವ್ ಯಾರ್ಯಾರು ಬರ್ತಾರೋ ಅವ್ರಿಗೆ ಕೊಡ್ತೇವೆ. ಎಲ್ಲಾನು ಹಂಗಿದ್ರೆ
ಆಯ್ತು
ನಾವೇನ್
ಸ್ವಾಮಿ.
ಮಾಡ್ಲಿ? ಏನಿಲ್ಲ ಪ್ರಕಾಶ್.
ಒಂದೇ ಒಂದು ಸಣ್ಣ ರಿಕ್ವೆಸ್ಟ್.
ಅದು ಪ್ರಕಾಶ್ ಆರ್ಗ್ಯೂ ಮಾಡಿಲ್ಲ. Some other petition some other advocate had argued.
ಹೌದು.
Appears. Otherwise, what he raised was a valid point. ಹಂಗ್ ಮಾಡ್ಬಾರ್ದು ನಾವು. ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ, ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ನಾವು ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಲಾಟ್ ಮೆನಿ ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಹೇಳ್ತದೆ. ಇದಾದ್ಮೇಲೆ ಮುಂದಿನ ಪ್ರಮೋಷನ್ ಇರ್ತದೆ.
ಹೌದು ಸ್ವಾಮಿ.
Suppose one fine day, Supreme Court in the final order reverses the interim order. What all should happen to these people?
That is your risk.
At my risk.
ಮತ್ತೆ ಒಂದು
Subject.
ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ.
Board.
ಜಸ್ಟ್ ನಾಟ್ ಅದರ್ವೈಸ್ ವಿಲ್ ಔಟ್. ಒಂದೇ ಒಂದು ನಾಳೆ ನಮಗೆ KPSC ಅವ್ರು ಏನು ಹೇಳಿಲ್ಲ ಅಂತ ಅನ್ಕೋಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಕೊಡಿ. ನೀವೆಲ್ಲ ಹೇಳಿರಿ ಅಂತ ಬರ್ದ್ಬಿಡ್ತೇವೆ ಒಂದು ಸೆಂಟೆನ್ಸ್.
ಹಾಗಲ್ಲ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಇದೇನಿಲ್ಲ.
And my lord, pursuant to the interim order granted by the Honorable Apex Court, 30% have been appointed, which is accepted by this state government.
That is in the 2006. I don't know
Yes.
the facts and circumstances and the stand taken by the government with respect to.
If it goes against you.
I
then
cannot.
you will
ಅವಾಗ you have to
come-
yield
then
everything
you-
ಅಷ್ಟೇ.
then you will come to.
ಇಲ್ಲ, ನಾವ್ ಹೇಳ್ಬಿಡ್ತೇವೆ ಅದು.
the mercy petition.
Yes, my lord.
ನಾವೇ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ.
I cannot claim equity.
Equity also you can't.
I cannot claim equity.
Yeah.
And my lords are right.
ಆ ರೀತಿನ ಬರೀತೇವೆ ನಾವು. ಬರ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ. The State Public Service Commission has presented this petition invoking writ jurisdiction of this court for laying a challenge to the State Administrative Tribunal's order dated 29/9/2022, whereby ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂದದ್ದು ಅಪ್ಲಿಕೇಶನ್
Respondent number.
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
Yes, ma'am.
2410.
ಕರೆಕ್ಟ್.
Application
First
number-
respondents application number 2410 of 22, having been favored, the following relief has been accorded to him. First, the operative portion of the order, Nodama, page 143, reads as under. ಇಲ್ಲಿ ನೋಡಿ, ಫ್ಲಾಪ್ ಹಾಕಿರ್ತೇನೆ, ಅದ್ ನೋಡ್ಕೊಂಡು ಮಾಡಿ. Learned counsel, panel counsel, senior panel counsel appearing for the commission vehemently argues that there is a great legal infirmity in the tribunal's order in as much as admittedly the height of contesting respondent herein falls short of 168 centimeters prescribed for the candidates in the recruitment fray, and therefore the relief could not have been granted to the petition, the said respondent. First stop. He also points out that the coordinate bench in WP number 469 of 2024 between Sri Manjunath P versus State and another disposed of on 12/7/2024 had failed to see that the concession in height arguably granted by the apex court in SLP number, CC number, SLP number, another.
SLP number 32186.
32186 of
2014.
32186 to 32199 of 2014 was only by way of an interim order, and therefore that would not lay down the law. And therefore, the coordinate bench decision may not be taken as having precedential value. First, ಬೇರೆ ಏನಾರ contention ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಸ್ವಾಮಿ even with respect to the 2006 batch, this is with respect to the 2016 notification.
First, he also points out that what happened to the earlier batch of candidates way back in 2006 cannot govern a new situation where the candidates now involved are in the 2016 batch, 16 recruitment process. First of all. So arguing, he seeks invalidation of the impugned order of the tribunal. First, next paragraph. Learned AGA appearing for the state and learned counsel caveator new appearing for the caveator respondent vehemently resist the petition, contending that if in the event of conflict between the requirement between the central rules and the state rules, the former will prevail over the latter because of constitutional injunction enacted in Article 254(2) in the light of the famous judgment, Tallach versus so and so, citation. So and so, semicolon. Arguably, the apex court in the subject SLPs has proceeded on this basis, permitting the candidates whose height falls short of prescribed 168 cms can also be in the fray. Semicolon. This aspect, according to these counsel advocates, having been considered by a coordinate bench of this court, there is no reason, justification for granting indulgence in the matter. First, they also answer, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned Caveators Council has also learned AGA appearing on our request for the state. First, the identical question has been treated by a coordinate bench of this court in Manjunatha's case Supra, wherein paragraphs 6, 7, 8 read, correct?
7 is
7, 8,
intention.
7, 8.
7, 8.
7 and 8 read as under. 7, 8 Next paragraph. The vehement submission of learned senior panel counsel appearing for the commission that what the apex court said in the SLP's Supra is only by way of interim order, and that would not become law under Article 141 of the Constitution of India, comma, appears to be attractive at the first blush. First off. However, this aspect of the matter in a way has been treated by the coordinate bench in P. Manjunatha by making the selection and appointment of 2016 batch people subject to outcome of the said SLPs.
2016 ಅಲ್ಲ ಸ್ವಾಮಿ batch ಅದು.
2000
ಅದು ಪ್ರಮೋಟಿ ಸರ್ ಸ್ವಾಮಿ ಅದು.
promoted.
2016 ಅಲ್ಲ.
Sentencing ಬರಿಬೇಕು. Read that. No, ಬೇಡ ಅಲ್ಲಿ. Selection and promotion of the respondents. Of the respondent.
No, my lord. They are already working as FDS, my lord.
Correct. Promotion
They are
alva.
promoted, my lord. Yes, my lord.
The respondent and such other candidates.
No, he is not a promoting, my lord. He is a DR, direct recruitee. ಅಲ್ಲಿ ಕೇಸ್ ಮಾಡಿರೋದು ಸ್ವಾಮಿ ಪ್ರಮೋಟ್
SLP ಅನ್ನೋದು promotion ಗೆ ಸಂಬಂಧ.
ಇಲ್ಲ.
ಅಲ್ಲಿ DR ಗೆ.
SLP direct recruitment.
168 is for direct recruitee only. Supreme Court said what has been prescribed for the direct recruitees ಇದೆಯಲ್ಲ, that should be made applicable to other candidates.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಹಾಗಂತ. ಕೋಆರ್ಡಿನೇಟ್
ಅವ್ರು ಹಿಂಗ್ ಹೇಳ್ಯಾರ ನಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೇಳಿದ್ರು. ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
They have interpreted. ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದು. ಅಲ್ಲಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಇದೆಯಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ by making the following observation at para 9
8 so.
No, 9. At paragraph 9 in the SLP, at paragraph 9 of the said decision, which reads as under. idnu ಹಾಕ್ಬೇಕು. ಅಲ್ಲಿ 6, 8, 7, 8, 9 ಅಂತ ಮಾಡಿಬಿಡು ಮೇಲ್ಗಡೆ, ಆಯ್ತಾ? ಇಲ್ಲಿ ಕೆಳಗಡೆ ಹಾಕೋದ್ ಬೇಕಾಗಲ್ಲ. Is taken care of, ಅಲ್ಲಿ ಹಿಂಗ್ ಬರಿಬೋದು. The contention of senior panel counsel appearing for the commission that what the apex court say is only by way of interim arrangement, and the main matter is still pending consideration, and therefore that would not become law under Article 141 of the Constitution of India, need not detain us any longer, in as much as that aspect is taken care of by the observations made at para 9 in the Manjunatha's case, which is already reproduced. Next paragraph. No other contention having been raised and petition being devoid of merits is liable to be and accordingly rejected. Courts having been made easy.
Lord.
Next.
My lord. Only another contention what I have submitted is we cannot reduce the terms and conditions of the notification ಅಂತ ಹೇಳಿ judgment ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು ಸ್ವಾಮಿ. I being a selecting.
No, not you. The Supreme Court has said now, I'll last sentence for you. The contention that the KPSC is only a selection body.
Yes, madam.
And therefore it has no discretion to relax the conditions prescribed by the recruitment rules, comma, does not merit much, a deeper consideration at our hands. Okay.
Great.
Okay.
But appointment may be made within a period of
ಯಾವ್ದು?
2
ಅಲ್ಲಿ
months.
ಏನಿದೆ ಅದು order. He cannot be worse off in his,
But our tribunal said within a period of 2 months, 3 months,
Yeah.
your lordship may extend the time for a.
ತೊಳಮ.
ಅಲ್ಲ appointment government ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ, ನಾವಲ್ಲ.
Correct.
Correct.
Has to do it.
Yes, ma'am.
The
Direction may
government,
be given to government, madam.
the government shall give effect to the order of the tribunal, impugned order of the tribunal within an outer limit of 2 months. Okay.
Grateful.
Comma, challenge to that having failed. Ah,
My lord, the next matter is, my lord, the
Ah.
same, but it is not with respect to height, my lord, it's knock knee, sir.
Knock knee.
Knock knee, my lord.
Huh?
That knock knee, ಎರಡು ಮಂಡಿ
knee,
ಜಾಯಿನ್ ಆಗುತ್ತಲ್ಲ
okay.
ಸ್ವಾಮಿ, knock knee.
okay.
So even in the first medical report, my lord,
Ah.
so not qualified. In the second medical report, she has qualified. But this honorable court has directed the respondent, contesting respondent to present before the court to undergo. But she has not, appeared in spite of the specific direction by my lordships.
ಮತ್ತೆ ಹೋಗಕ್ಕೆ ಹೇಳಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲ, my lord, matter is covered by the coordinate bench judgment.
28/7/2023.
I'm sorry, my lord, I have only one set.
All right, ಅದು ಕೊಡಿ, ಒಂದ್ ಇದ್ದಿದ್ದು ಅದನ್ನ ನೋಡೋಣ ಅಂತ.
ಒಂದ್ ಕೊಟ್ಟಿದೀನಿ, ಅದು ಶಿವನಂಜೇಗೌಡ, ಅದೇ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
Shivananjegowda, my lord, there before this honorable court, my lord, the KPSC has fairly considered before my lordships, before this honorable court, to send the candidate for medical examination. We don't have any vengeance with the candidate. But there, my lord, I have requested my lordships, direct the government to present before both the doctors who have disqualified at the one hand and qualified at the another hand. Because we being a selecting authority, based on the certificate given by them, we will select, my lord. But the stone will be thrown to us. KPSC is not working properly. Even in this case also, my lord, I request I will fold my hands to my lordships.
Yeah, not necessary.
No,
You can
direct,
very vociferously-
no, my lord, because of
Touching your
this
hands.
case, I have faced so many
ಅಲ್ಲ,
humiliations, my lord. One minute, sir. I myself faced so much humiliation before the tribunal as well as this honorable court. You KPSC people are not following the rule of law and thrown, my lord. Hence, in this case particularly, I request my lordships to direct the government to keep both the doctors before this honorable court and send the candidate to the particular board found by my lordships and get the report, my lord, and take appropriate action against the doctor who has committed. One should not do and repeat in future, my lord. In the interest of that, keeping in that view, I request my lordships to do that, my lord. It's by
Dr. Sarah.
Doctor, my lord.
Before that, my lord, only one submission. In the first round, my lord, I have been disqualified. But KPSC itself has referred it to the
Correct.
second doctor.
ಆಯ್ತು, ಅದಕ್ಕೆ ಚೇಂಜ್ ಹೆಂಗಾಗತ್ತೆ ಇದು?
Second doctor has given the opinion that I am qualified. Lord, what was the occasion for the KPSC to send it for second occasion? It is my lord, as portrayed by my learned friend, it may not be the facts. Why KPSC has sent it for a second doctor? Lord, page 63. In the my lord, second opinion, I have been qualified.
My lord,
It is the KPSC which has referred. Can he, my lord, blame the doctor now? Who has referred for the second doctor? It is the KPSC. Page 63, my lord. 4/2/2016 ಬ್ಯಾಚ್ 1 ಅಂತಿದೆ.
ಅಧಿಸೂಚಿಸಲಾದ
ಸಾರಿಗೆ ಇಲಾಖೆಯಲ್ಲಿನ ಮೋಟಾರ್ ವಾಹನ ನಿರೀಕ್ಷಕರ ಹುದ್ದೆಗಳಿಗೆ ಮೊದಲನೇ ಹಂತದಲ್ಲಿ 1:2 ಅನುಪಾತದಲ್ಲಿ 1:2 ಅನುಪಾತದಲ್ಲಿ 279 ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ದಿನಾಂಕ 7/10/2016 ಮೂಲ ದಾಖಲೆ ಪರಿಶೀಲನೆಗೆ ಆಹ್ವಾನಿಸಿ ನಂತರ ದೈಹಿಕ ಅರ್ಹತೆ ಪರೀಕ್ಷೆಗೆ ಒಳಪಡಿಸಲಾಗಿತ್ತು. ಅದರಲ್ಲಿ ಒಬ್ಬ ಅಭ್ಯರ್ಥಿಯು ಗೈರು ಹಾಜರಾಗಿದ್ದು ಹಲವು ಅಭ್ಯರ್ಥಿಗಳು ಅನರ್ಹರಾದ ಕಾರಣ ಮತ್ತೊಂದು ಅವಕಾಶ ನೀಡಲು ಆಯೋಗದ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿದ್ದು. Lord, it is the decision of the KPSC. KPSC has referred and my lord, KPSC says that my lord, take action against the doctor.
I will answer
But whether such my lord,
Yes,
lord, it is not a my lord, I am with great respect to my learned friend. It is not a, my lord, I don't want to say anything more.
No,
But,
that's why to put an end to it, my lord.
What
In-
would- Why did you send, why
But
you
it
sent
is the KPSC which has,
I will answer.
How many times you are, they
My
sent
lord.
it only once.
My lord.
You are repeating it again.
Yes.
and again.
Shall I make my submission, my lord?
Yes.
In the earlier case also, my lord, the same Sikandar Babu has sent for the second medical test. Second medical test report, I may be permitted to pass on. They have stated that he is 168.
ಯಾವ ಕೇಸಿಗೆ?
Earlier this one.
Earlier
ಅಲ್ಲ, ಅಲ್ಲ, ಹೇಳಿದ್ದು ಸ್ವಲ್ಪ ಈ 11ರಲ್ಲಿ ಅವರು ಇದ್ದಾರೆ.
Next point.
There, before this honorable court, when it measures, it was 162. In this case also, earlier, she has certified that she had knock knees. The KPSC, my lord,
Why those two persons are disturbing us? Ask them. Kariri ಅವರು. Why are you disturbing the court? Call the police. Call the police. Arrest them till evening. ಏನ್ ನಿಮ್ಮ ಹೆಸರು? Come this side. Come this side. ಬರೀ ಈ ಕಡೆ. Why are you disturbing the court? ಇಬ್ರು ದೂರ ಕೂತ್ಕೊಳ್ಳಿ. Yes.
Lord, based on the request made by the candidates, my lord, the commission has taken the decision to send the candidates for the second time, these 11. Later on, the KPSC again received objections. KPSC doesn't have the provision and power to consider and send the candidates for the second time. Hence, though we have sent, we have not considered any of the candidate.
No, that makes no sense. We have only printed the fake notes, but we have not put them in circulation. ಅಂತ ಹೇಳ್ದಂಗೆ ಆಗ್ತದೆ. Why did you send? Why did you print? Is the question.
My lord, we have sent to the board to reconsider because they have requested, my lord, few candidates.
But so many people will request. There is a report. Straightway you should have acted upon it. They
Yes,
may
my lord.
request 100 and odd. Why did you send? Now having sent now, how can you say that we are not bound by the report? You are bound by the report.
My lord, the statute not empower the commission, my lord, to accept the,
No, but you have done that. You have sent. Now you cannot
but
contend all that.
we made the submission before the tribunal, my lord, stating that we came to know that without having such powers, we have sent it. Now we are not considering that. We have considered the first medical test reports, my lord, and
Say that, can't say that. Having said, you were not happy with the medical report because they raised the objection, candidates. You should have said, Nodappa, rightly or wrongly.
ಹೌದು ಸ್ವಾಮಿ.
There is a medical report. ಅಲ್ಲಿ ಏನೋ ವ್ಯವಹಾರದಂಗೆ ಕಾಣ್ತದೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಸ್ವಾಮಿ ನಾನು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಏನಂತಂದ್ರೆ,
ಅದಕ್ಕೆ ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ
ಅಲ್ಲ ಮೂರನೇ ಒಂದು ಬೋರ್ಡ್ ಅದಕ್ಕೆ ನಾಳೆ ನಾವು ತಪ್ಪು ಮಾಡಬಾರ್ದು, ಅವರು ತಪ್ಪು ಮಾಡಬಾರ್ದು, ಆಗ ಆಗ್ಬಾರ್ದು ಅಂತ ಒಂದು
ಬೇರೆ
ರಿಕ್ವೆಸ್ಟ್
ಏನೋ ಕಂಡೀಷನ್ ಇದೆಯಾ?
ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅಷ್ಟೇ.
ಬರ್ಕೊಳ್ಳಿ, dismissed. Dismissed. Since it is the KPSC which had referred the matter for fresh medical examination, which aspect is reflected at para 63 of the paper book. Dismissed. ನಮ್ದೊಂದು judgment ಇದೆ. We have rejected the contention in Dharwad. Huh? ಎಲ್ಲಿ ಏನ್ ಅನ್ಸೈಂಟಿಫಿಕ್ ವೇ?
ಅಲ್ಲಿ ಫಸ್ಟ್
ಏನ್ ವಾಟ್ ಇಸ್ ದಟ್?
ಫಸ್ಟ್ ರಿಪೋರ್ಟ್ ಮಾಡಿದಾಗ ಸ್ವಾಮಿ, ಮೆಡಿಕಲ್ ಟೆಸ್ಟ್ ಮಾಡಿದಾಗ ಕ್ಯಾಮ್ರಾನಲ್ಲೆಲ್ಲ ಅದು ಇದಿದೆ, ಏನು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ವಿ, ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
ವೇರ್ ಇಸ್ ದ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಪ್ರೊಸೀಜರ್? ಪ್ರೋಟೋಕಾಲ್ ಏನಿದೆ ತೋರಿಸಿ. ವೇರ್ ಇಸ್ ದಿ ಪ್ರೋಟೋಕಾಲ್? ಅವ್ರು ಹಿಂಗೆ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದೆ ಪ್ರೋಟೋಕಾಲ್ ತೋರಿಸಿ. ನೀ ಚೆಕ್ ಟೆಸ್ಟ್ ಇದು.
ನಾಕ್ ನೀಸ್ ಹೌದು
Knock knee
ನಿಂತ್ರೆ
test
ಗೊತ್ತಾಗುತ್ತೆ, ಹೀಗೆ ಬರುತ್ತೆ.
ಮತ್ತೆ ಇದಕ್ಕೆಲ್ಲ ಏನ್ ಮಾಡ್ಕೊಳ್ಳೋದಿತ್ತು? ದಿ ಸೆಕೆಂಡ್ ಕಂಟೆನ್ಷನ್ ದಟ್ ದಿ ಸೆಕೆಂಡ್ ಡಾಕ್ಟರ್ ಇದನ್ನು ಕಾಲೇಜಿಯಂ ಅದು
ಡಾಕ್ಟರ್ ಸ್ವಾಮಿ ಬೋರ್ಡ್,
ಎಷ್ಟು ಜನರು?
ಮೆಡಿಕಲ್ ಬೋರ್ಡ್.
Second collegium of doctors has not followed the protocol which the earlier collegium had followed, and therefore its report cannot be acted upon is ridiculous, to say the least, in the absence of demonstrable any protocol of the kind. Full stop. ಅಲ್ಲಿ ಏನ್ರ ಇವ್ರು ಹಿಂಗೆ ಮಾಡ್ಬೇಕು ಅಂತ ಏನ್ರ ಇದೆಯಾ? Dismissed.
We can't ಇದು.
The the respondent state shall give effect to the order of the tribunal within an outer limit of 2 months. Yes,
Grateful.
next. ನಮ್ದು ಧಾರವಾಡ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಮೈಸೆಲ್ಫ್ ಅಂಡ್ ವಿಜಯ್ ಕುಮಾರ್ ಅದು ತಗೊಂಡ್ ಕೊಡ್ಬೇಕು ಅದನ್ನ. ಏನು ಪ್ರಿಪರೇಷನ್ ಮಾಡ್ಕೊಂಡು ಬರಲ್ಲ, ಎಲ್ಲ ನಾವೇ ಹೇಳ್ಬೇಕಾ? ಸಾರಿ ಏನು ನಮಗೆ ಕೊಡಿ.
My lord, I appear for the petitioner, my lord.
Yes, Madam Shiva.
Yes, sir. Yes, my lord. Today I have some inconvenience, my lord. Kindly, it may be taken on any other day, my lord. I have informed the other side, my lord.
All right. Adna, in the second week of January 2025, on request of the CG, London CGC appearing for the petitioners. Next.
Much obliged, my lord.
Okay. ಆಯ್ತಾ? ಅದು ಆರ್ಡರ್ ಸ್ಪೈಸ್ ಬೇಗ. ಧಾರವಾಡ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ನೀನೇ ಇದು ಮಾಡಿದ್ದೆ, ಅದನ್ನೆಲ್ಲ ರಿಪೇರಿ ಮಾಡಿದ್ದಿ ಜಡ್ಜ್ಮೆಂಟ್. Six.
ಭಯ
ಇದಿಲ್ಲೇ ಇಟ್ಟಿರ್ತೀನಿ, ಮಧ್ಯಾಹ್ನ ಟಿವಿ ಬರ್ತಾರಲ್ಲ ಯಾರನ್ನ ಅವ್ರಿಗೆ ಬೇಡ ಅನೌನ್ಸ್ಮೆಂಟ್ ಇದು ಅನೌನ್ಸ್ಮೆಂಟ್ VC ಒಂದು ಸಿಂಗಲ್ ಇಷ್ಟು ತಗೊಂಡೋಗ್ತೀನಿ ಅಷ್ಟೇ. ಇದು ತಗೊಂಡೋಗ್ಬಿಡಪ್ಪ. ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್
ಬಂದು ನಾನು
सिंगल का या फिर 230 का इधर
ಲೀವ್ ಮೀಟಿಂಗ್ ಮಾಡಿ ಲೀವ್ ಮೀಟಿಂಗ್
ಲೀವ್ ಮೀಟಿಂಗ್ ಅಂತ
ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋಣ. ಈಗ ಅಲ್ಲೇ ಲೀವ್ ಅಂತ ಲೀವ್ ಅಂತ ಮಾಡಿ ಅದನ್ನ ಲೀವ್ ಮೀಟಿಂಗ್ ಅಂತ ಆಮೇಲೆ ಇದು ಫುಲ್ ಕ್ಲೋಸ್ ಆಗ್ತದೆ. ಅಲ್ಲೇ ಬ್ಯಾಕ್ ಕೆಳಗೆ ಕ್ರೋಮ್ ಓಪನ್ ಅದ ನೋಡಿ, ಅದನ್ನ ಕ್ಲಿಕ್ ಮಾಡಿ. ಅದನ್ನ ಕ್ಲಿಕ್ ಮಾಡಿ ಆಡಿಯೋ ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಕೊ. ಅದನ್ನ ಕ್ಲಿಕ್ ಮಾಡಿ ಮೇಲೆ ಆಡಿಯೋ ವಿಡಿಯೋ ಮ್ಯೂಟ್ ಇರ್ತದೆ. ಹಾ ಅದನ್ನ ಎರಡು ರೆಡ್ ಅವಲ್ಲ ವೈಟ್ ಇರ್ತೀವಿ ನೋಡಿ ಯಾರು. ಹಾ
Sir, is it audible?
Yes,
Anita madam,
audible.
audible sir?
Yes, audible, madam.
Yes, sir. ಅಲ್ಲಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಬೆಳಗ್ಗೆ ಚೇಂಜ್ ಮಾಡಿದ್ರಾ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್? ಈಗ ಮಾತಾಡಿದ್ರಲ್ಲ.
Court officer. Court officer.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಬೆಂಗಳೂರು ಬೆಂಚ್ ರೀ.
ಹೌದು ಮೇಡಮ್, ಬೆಂಗಳೂರು ಬೆಂಚ್.
ಬೆಂಗಳೂರು ಬೆಂಚ್ ಅಲ್ರಿ? ಇಲ್ಲ ಧಾರವಾಡ ಬೆಂಚ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದೀರಾ, ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದೆ. ಅಲ್ಲಿ ಆ ತರಾನೇ ಕಾಣಿಸ್ತಾ ಇದೆ.
ರೆಡಿ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ.
उनका सब नहीं है। हाँ, धारवाड़ का मैटर, धारवाड़ में कौन से नहीं है? फोन करो, धारवाड़ में नंबर है।
हाँ हाँ ಬರ್ತೀನಿ. Yes.
Appeal number 1, D. Srikanthegowda, D. N. Manjunath.
Correct.
Please, I have deposited the entire amount of 1 crore 40 lakhs. Well, they have preferred SLP. The SLP has been dismissed against my lord's decision.
Yeah.
Now they have filed an application for withdrawal of amount which I have deposited.
ಕೊಲಿ ಅಂತನಾ ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ದಿರ ಹಂಗೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ, ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
My lord, one kind indulgence, my lord. In view of my lord, depositing entire amount, I may be permitted to, my lord, obtain the original of exhibit P1 to P8 and D1 to D5, my lord. So that, because my lords, they have withdrawn the amount as directed, my lords.
Correct. ಎಲ್ಲಿದಾವು?
My lord, records is before the Sama court only.
Exhibit?
So, my lord,
ಯಾವ್ಯಾವ exhibit?
exhibit P1 to P8, my lord.
P1 to P8.
P8.
ನಿಮ್ documents ಅನ್ನೋದು?
My lord, it is pertaining to the defendant's documents, which my learned friend produced before the trial, marked before the trial court.
Okay. ಬೇಡ ಏನ್ ಬೇಡ, ಇಲ್ಲ ಒಂದ್ ಸ್ವರ ಅಲ್ಲ, ಈಗ ಮತ್ತಿಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟು ಮತ್ತೆ ಅವರು ಇನ್ನೊಂದು ಕೇಸ್ ಫೈಟ್ ಮಾಡಕನ? ಬ್ರದರ್, to permit them.
Yes, sir. Yes, sir. It should be allowed.
Pursuant to our judgment dated 19/4/2024, the appellants have deposited a sum of rupees 1,40 lakh. 40 lakh. And their counsel seeks a direction to the registry to deliver the original documents. Ikkade ಏನು original documents ಯಾವ್ದು?
My lord, before the trial court, my lord. Exhibit P1 to P8.
Exhibit
P1 to P8.
P1 ಏನು, P8 ಏನು?
Please, my lord.
What is P1, what is P8?
Please.
Original documents.
My lord, exhibit P1, my lord, special power of attorney.
Special power of attorney dated so and so.
Letter, allotment letter dated 22/10/1965.
ಏನದು?
Allotment letter of VDA, my lord.
Exhibit ಏನು?
Exhibit P2, my lord.
P2.
P2. Then it is not nice. Allotment letter, my lord. Exhibit P2.
Allotment, original allotment letter dated 22/10/1965.
Please, ma'am. Then
At exhibit P1.
P2. P2.
And
P3, gift deed dated 26/4.
original gift deed, registered gift deed dated
26/4/2004, my lord.
26/4/2004. That
Then
exhibit P2.
P3,
P8,
P3, my lord.
P3.
Please, ma'am.
ಮತ್ತೆ
P4, Kata certificate, my lord.
ಇಷ್ಟು ಮೂರೇ.
My lord, then Kata extract.
Kata certificate dated.
My lord, it is not furnished, the date ಇಲ್ಲ.
The Kata certificate at exhibit
P4, my lord.
P4.
P5, Kata extract, my lord.
Kata extract, you can extract 100 extracts again.
Tax paid receipt P6, my lord.
Kata extract ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
Please, man. Agreement of sale at P7, my lord. Enter between the.
Agreement to sell dated
21/5/2009, my lord.
21/5/2009.
Please, my lord.
At exhibit
P7, my lord.
P7.
And P8, Shara dated 21/5/2010, my lord.
And endorsement stroke Shara dated
21/5/2010.
21/5/2010 at exhibit
P8, my lord.
P8.
My lord. Then, my lord, we have produced originals, my lord, D1, D2, D3, D4, D5, that is Kata extract, attested copy of Kata certificate.
ಒಂದು ನಿಮಿಷ. D1 to
D5, my lord.
ಇದೇ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಪಡೋದು.
ಇದೇ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧ.
And all the documents produced by the defendant side.
Please.
At exhibits D1 to
D5, my lord.
D5.
Please.
To the appellants. First stop. ನಿಮಗೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅದಕ್ಕೆ. Learned counsel appearing for the respondent plaintiffs standing tall at the bar signifies no objection, capitals, inwards, to this prayer. First stop. He presses his application seeking a direction for refund of the amount deposited by the appellants in the sum as specified above, by way of equal apportionment between the respondent number 1 and respondent number 2. Respondent number 1 ಯಾರವರು? ಶ್ರೀಮತಿ ಮೀನಾ first respondent Srimati Meena A. Jain and the second respondent Srimati Darpan A. J. First up, counsel for the appellant submits that he has no objection for the refund of this money along with the interest accruing due thereon. First up, in view of the above, the following order is made. First up.
One kind indulgence. They may, my lord, directed to cooperate for the cancellation of the agreement of sale before the sub-registrar, my lord, so that matter will be settled fully, my lord.
And if you do not cooperate, what he should do? Therefore, what we will do is 90% of the amount release ಮಾಡಿಬಿಡ್ತೇವೆ. ರಿಮೈನಿಂಗ್ 10% ಇದೆ ಅಲ್ಲ, ಇದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡ್ಕೊಂಬನ್ನಿ, ಉಳಿದಿದ್ದು ಕೊಡಿಸ್ತಾರೆ. ಅದರೊಳಗೆ ಇನ್ನೊಂದು ಕೇಸ್ ಆಗತ್ತೆ, ನಮ್ಗೆ ಅದನ್ನೇ ಮಾಡಬೇಕಾಗತ್ತೆ ಬೇರೆ.
ಅಲ್ಲ, ಕೋಆಪರೇಟ್ ಮಾಡಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ please.
So we'll make an order.
Please make an order.
Cancellation of the said.
Please.
ಅಲ್ಲಿ ಇನ್ನೊಂದು contention ಬರೀ. Learned counsel for the appellant also submits that there has to be cancellation of the subject registered agreement. Another registered agreement dated,
my lord, 21/5/2009, my lord.
21/5/2009. ಅದು ಯಾರ ಹೆಸರಿಗೆ ಮಾಡಿದ್ರು?
In 1 and 2. By the appellant.
21/5/2009
at exhibit P7, my lord.
Dated so and so, to which counsel for the respondents readily agrees. First, in the above circumstances, the following order is made. One, the subject application filed by the respondent plaintiffs having been favored, registry is directed to pay to the applicant respondents the amount in deposit along with the interest that has accrued due in the ratio of 50:50. Forthwith. After ascertaining their credentials. Number 2. Original ಎಲ್ಲಿದಾವ?
Please, man, before the.
ತೆಲಗಿ ಕೋರ್ಟಿಗೆ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಎಲ್ಲವನ್ನು.
Please, man, I may permit it to.
Registry to send back the original TCR and the registry of the court below shall deliver to the appellants the documents ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದೀವಲ್ಲ ಎಕ್ಸಿಬಿಟ್ P1, P2, P3, P4, 7 ಎಲ್ಲ ಮ್ಯಾಚ್ ಮಾಡಿದಲ್ಲ ಅದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್. In addition to and also all the documents produced by the appellants in exhibit D series, please, D series, after retaining copies thereof in the file, please. But ಬೇರೆ ಏನಲ್ಲ. Next paragraph. The agreement dated
21/5/2009, my lord.
2009, which is registered. Registered agreement ಅನ್ಬೇಕು. So and so hereby stands cancelled.
Rajajinagar Sub-Registrar Office.
Hereby stands cancelled, and a formal endorsement to that effect shall be drawn by the sub-registrar, jurisdictional sub-registrar, on the production of a copy of this judgment. Forthwith, please. Without soliciting any document, record, or anything of the kind from the side of the respondents. Please. ಇಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ಒಂದು ಸ್ವಲ್ಪ ಸ್ಟ್ರಕ್ಚರ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಸ್ವಲ್ಪ ಬೇರೆ ಆಗ್ತದೆ. Please. But this order will remain in. All right?
Grateful, man.
All. Orders on I1 having been allowed, following direction has been passed. Okay. Yes.
Seal number 2. For further hearing, Sumitra K. Raghavendra. Sumitra.
We'll have it in January after his brother comes back. Or you want release from partner? Whichever way you suggest. We remember, if you say, let it go before some other bench, we will say that also. ಅಲ್ಲ ನೀವ್ ಹೇಳ್ದಂಗೆ ಮಾಡ್ಬಿಡ್ತೀವಿ ಅಲ್ವಾ ಅವ್ರಿಗೆ ಸೇಮ್ ಹಂಗಾಗಿ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ January 2025. Second week is also short one. The first ಮಾಡ್ಬೋದು ಅಷ್ಟೇ, ಇಲ್ಲಿ ನೋಡೋಣ. As requested at the bar. Yes. 3.
Number 3.
I appeal for the appellant, my lord. On the line, I am there. Regarding a specific performance suit.
Correct. Brother, do you remember this case? I do not remember. Really, I confess.
Yes, sir. Sir, we leave it to Mr. Sharma to.
Yes, Mr. Narayan.
Yeah, I may have to start again. Of course, ತುಂಬಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಲಿಲ್ಲ, ಸ್ವಲ್ಪ ಆಗಿತ್ತು. ಏನು ಅಂತ ಹೇಳಿ ಅಷ್ಟೇನೆ. Then ತಮಗೆ ಬಿಟ್ಟಿದ್ದು, ನಾನು ಅದ್ರ ಬಗ್ಗೆ ತಾವು
ನೀವ್ ಹೇಳಿ, ನಿಮ್ಗೆ ಆಪ್ಷನ್ ಕೊಟ್ಬಿಟ್ಟಿವಿ ಈಗ.
No, I can't select that way.
Brother, we'll release it from part.
Yes, sir.
ತಮ್ಮ ಕನ್ವೀನಿಯಂಟ್.
Okay. Release the matter is released from part. Register to post it before the roster bench in due course. Single. All right, I'll come back.
Yes, sir.
Yes.
Second week of January.
Second week of January.
Continue. Okay.
Yes.
All right. Yes, sir. Yes. Good.
Single bench matters for orders. Seal number 1. Keshavar Agnihotri.
Padi. Yenu. List kodi. Furnishing copies, etc. First time. ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿತ್ತು?
24/7/2023.
Entry ಮಾಡ್ರಿ ಏನ್ರಿ ಇದೇನು? Steps to be taken within 1 week, failing which RP stands rejected. Next.
Seal number 2, Vijay Kumar.
Compliance report. ಪಾಸ್ವರ್ಡ್ ಏನು ಆಗಿದೆಯೇನೋ? ಕಂಪ್ಲೈ ಮಾಡ್ಯಾರ? ಲರ್ನೆಡ್ AG ಏನಾ? ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದೆಯಾ? We made to pay cost of rupees 1 lakh.
Petitioner ಬಂದಿಲ್ಲ. Comply
ಬಂದಿಲ್ಲ.
ಆಗಿದೆಯಾ?
Their favor
Compliance ಆಗಿದೆ.
denied.
Learned AGA submits that in terms of threatening order of this court dated 12/8/2024, the compliance has already been made. First off,
I will
the
file a memo
submission
along
is-
with that.
the submission is accepted.
File a memo also.
Next.
Seal number 3, NG Padke.
My lord, conversion has taken place, my lord.
They have done the
Please,
conversion now.
please, my lord.
ಯಾಕೆ ಇಷ್ಟು ದಿವಸ ಯಾಕೆ ತೊಗೊಳ್ತೀರಿ ನೀವು ಕನ್ವರ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ, ಆರ್ಡರ್ ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ? ಅಲ್ಲಿ ಥ್ರೆಟ್ನಿಂಗ್ ಆರ್ಡರ್ ಇತ್ತಾ ಸಂಖ್ಯಾ ಸಾಧನ
Threatening order.
ಇತ್ತಾ?
Ittittu.
ಅವಾಗ ಮಾಡ್ತಾರ, ಎಲ್ಲರೂ ಮಾಡಲ್ಲ. In view of threatening part of the judgment dated 8/11/2022, the compliance of the mandate is reported. First, no further orders are required.
Much obliged.
No further orders. Next.
Seal number 4, Gangadhar.
Badi. ಏನ್ recalling ಇದು?
Peremptory order.
Peremptory order. The petition was dismissed with peremptory order dated 2/8/2021. First, the application supported by an affidavit is now moved, seeking recall of the said order. A plausible explanation having been given in the said application, the said application is favored and the peremptory order of dismissal stands recorded. First, as a consequence, the writ petition is restored to the board and registry to post the same before the roster bench, subject to the condition that the petitioner shall present to the Advocates Association Library a set of 2 books, Kuli Hunase Mara, Mavina Mara, Kuli Mavina Mara by P. Lankesh, within 3 weeks, failing which the peremptory order would revive on its own as Phoenix. Yes. Next.
Seal number 5, AG Balloli.
Yes, Mr. Belluli,
My lord, that.
5,000.
Yes,
Wait,
that-
cost of rupees transmission charges.
I think they have paid it actually. I don't have, I'll just, 1 week's time I give you, I will just acknowledge that.
Pay madira.
Hey, ಮಾಡಿದೀನಿ ಅಂತ he told me, I'll have to verify that.
ಅದಕ್ಕೆ ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು. ಇದಕ್ಕೆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿಬಿಡ್ತೇವೆ ಅಷ್ಟೇ. ಮತ್ತೆ ಇದು ಬಂದ್ರೆ ದುಡ್ಡು ಕೊಡೋರು ಯಾರು? ಎಷ್ಟು ದುಡ್ಡು ಎಷ್ಟಾಗ್ತದೆ ಇದರಿಂದ? ಎಷ್ಟು ಜನರ ಟೈಮ್ ಎಷ್ಟಾಗ್ತದೆ? Just tell me, go and ask.
It's a transmission to the Gulbarga Kalburgi branch case.
There is an order which you have suffered. It may be a wrong order, but you have to comply with the order.
On the, due to the jurisdiction wise, it was, order was here and transferred to the Gulbarga.
ದುಡ್ಡು ಕೊಟ್ಟಾಗಿದೆಯಾ?
That I told them actually I need to verify my lord.
ಎಂತ ಸಬ್ಮಿಷನ್ ರೀ? ಈಗ ಫೋನ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ, ಈಗ ಮತ್ತೆ ಪೋಸ್ಟ್ ಮಾಡಿಸಲ್ಲ ನಾವು. 25 ಕೇಸ್ ಪೋಸ್ಟ್ ಆದ್ರೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲ ಇಲ್ಲೇ ಇರ್ತಾರೆ. ಇನ್ ವ್ಯೂ ಆಫ್ ದ ಫುಲ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ ನಾವು ಮಾಡಿದ್ವಿ. ಕೊಟ್ಟಿಲ್ಲ. Registry shall not transmit the papers of the case in WP number so and so. Since payment as ordered by this court has not been vouched, vouched. Okay. Yes, next. Nor registry shall return any of the papers or copies thereof to the petitioner from the file. Yes. Next.
Hearing on a seal number 6, V. Anand.
6. Yes, brother. Anand.
V. Anand.
In filing, days in filing, setting aside abatement, etc. A set of 3 applications have been moved. First stop. IA 1 of 2023 seeks condonation of delay of 615 days in filing the LR application. Semicolon. IA 2 of 2023 seeks an order for setting aside abatement of the proceedings on the death of P3, petitioner 3. Semicolon. The third IA number 3 of 2023 seeks leave of the court to bring LRs of the deceased petitioner number 3. First, all the applications are supported by individual affidavits. First, applications of the kind are ordinarily favored, comma, there being plausible explanation for the delay grouped in filing IA number 1 of 2023. First, accordingly, delay is condoned and abatement, statutory abatement is set at naught. First, the third application in IA number 3 of 2023 having been favored, LRs of deceased petitioner number 3 are permitted to be brought on record to represent the estate of deceased. First, petitioner to amend the cause title and file the amended petition as well within 2 weeks. Yes.
Seal number 7, BB Patil. Sundaresh.
My lords, this honorable court, my lords.
Delay condone marna. Delay 49 days in file. Application in IA number 1 of 2023 supported by an affidavit seeks condonation of a short delay of 49 days. First off, explanation being plausible and delay grouped being too short to be little, comma, the said application is favored and delay is condoned in filing the review petition. First, yes, brother, what has happened?
My lords, may please have ink page number 23 of the review petition, my lords, where the impugned order internal page number 10, my lords, will find. Our grievance, my lords, is only to the extent of, my lords have internal page number 10.
10.
My lords, may please come to the bottom paragraph where the directions are. It says, in view of the above, these writ petitions are disposed of directing the respondent BDA to accomplish the task of transfer of records and such other things to the slum clearance board.
Within an outer limit.
Within
Yes.
and out. My lords, our grievance is, my lords may please now have the previous page, para 3. Our submission, my lords, was previous page, para 3 of the order. It says learned counsel for appearing for slum clear submits that till the transfer is duly accomplished in terms of government order. My lords, not just the records. The lands per se have to be transferred to me vide section 27 subclause 3 of the Slum Clearance Act.
What do you say?
They are the sufferer, either the government,
Who appears for the?
BDA has to.
BDA, yaar idhar BDA?
BDA, my lords, the commissioner is served on
Suraj Patil.
Suraj Patil. Our only issue, my lords, is just a minor insertion there saying not just the
land also to be transferred.
No, my lords, the land to be transferred as per section 29 subclause 3 of the Slum Clearance Act. My lords, may please have the statute. I'll pass on.
Sorry.
Because if just the records are transferred to me, it may be a futile exercise.
Land also has to be transferred.
Per se, because there is an order already by government. That's section 27, my lord, subclause 3 may kindly be seen.
Where any slum area is located on the land belonging to the government or any local authority, the government or local authority may subject to such conditions as it may impose transfer to and vest in the board such land. Authority may.
My lords, if it is not transferred to me, I can't give him a title. It is not vested in me only. I can't give him any title. Because there might be a gap in terms of the title, because now per se, my lords, the title is with the government and the BDA. If BDA transfers it to,
Prayer in it, petition dal torsi.
my lords,
Show the prayer.
I am a review petitioner where I was a respondent therein, my lords.
You are
I was a respondent therein.
Slum board.
Our prayer ನೋಡ್ಬೇಕಾಗತ್ತೆ. Our prayer ಸೇಲ್ ಡೀಡ್ ಕೇಳಿದಾರೆ ಅವ್ರು. ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಕೇಳಿ
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಬೇಕಾಗತ್ತೆ.
ನನಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಲೇಬೇಕು.
Learned senior panel counsel appearing for the review petitioner points out the infirmity in the judgment now put in review, whereby the petition was disposed of to the effect that in the absence of transfer of the land as contemplated under section 27(3) of Karnataka Slum Areas Development Act 1973, no relief which the writ petitioner had sought for execution of the by way of execution of the conveyance cannot be made, cannot be effectuated. First off, learned counsel appearing for the review petitioner. You are the review petitioner.
No, I am the review petitioner.
Petitioner.
He is the
Sorry,
petitioner.
writ petitioner avukale, review alla. Writ petitioner anta. First off, learned counsel appearing for the writ petitioner submits that who would grant land and title to the land is not his business, provided that the land is allotted to him and title is duly conveyed. First, I trusted him submission. Learned government advocate obviously has to stand by the government order dated
It's in para 3.
23/2/2021.
Please.
Which needs to be given effect to in terms of subsection 3 of section 27(3).
Please.
First off, there is none from the side of the BDA, despite service of notice. First off, however, that will not deter the court from deciding the cause in accordance with law. First off, in the above circumstances, this review petition having been favored and the subject judgment having been subject judgment will have another clause in its operative portion to the effect that the slum clearance board shall deliver.
No.
Sorry.
The BDA.
The BDA shall deliver the subject land in favor of the review petitioner for giving effect to the relief column of the judgment. This to be done within a period of
In terms of section 27.
in terms of section 27(3)
of the slum
of the act within a period of 8 weeks.
Please.
First off, registry to send a copy of this judgment to the commissioner BDA, whose counsel was absent when the matter was taken up. Yes.
Deeply
By
obliged.
speed post.
Deeply obliged.
Yes, sir. Little change, whichever, we have understood the point.
Please.
Only some little textual.
That is
change.
all was our review, my lords. Only we wanted that.
Next. You
Deeply
are only
obliged.
repeating what I have said in the judgment. Yes,
Deeply
next.
obliged. Deeply obliged.
Next.
Number 8, PC Sitaram Rao.
When were you served with the copy? The application in IA number 1 of 2024, supported by the affidavit, seeks condolation of 928 days in filing. First off, till date, no objections are filed to the. No. Where is the objection? As on, ನೋಟಿಸ್ ಆಗಿದೆ. ಪಿ ಬಾಲಕೃಷ್ಣ ಅಂಡ್ ಅದರ್ಸ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಅವ್ರಿಗೆ ನಾನು ಫೈಲ್ ಮಾಡಕ್ ಮುಂಚೆ ಸರ್ವ್ ಮಾಡಿ ಹಾಕಿದ್ದೀನಿ.
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇರ್ಲಿ ಒಂದ್ ನಿಮಿಷ. ಮೈ ಸಬ್ಮಿಷನ್ immediately after 2 days of the judgment, I have moved the IA. I have brought it to the notice of the court. Subsequently, on a suggestion, I have filed review. The delay is virtually no delay.
ಅಲ್ಲ ಅದು ಅವ್ರು ಏನಾರ ಒಂದು ಹೇಳ್ಬೇಕಲ್ಲ ಅದ್ರ ಮೇಲೆ ಅಟ್ಲೀಸ್ಟ್
IA ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
ಜಸ್ಟಿಫೈಡ್ ಬಿಕಾಸ್ ಹಿ ವಾಸ್ ನೆವರ್ ನೋಯಿಂಗ್. ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ನಾವು.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಬಟ್ he knew.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್? Only of respondent?
ಇಲ್ಲ.
Respondent. Shri so and so accepts notice.
ಅಲ್ಲ ಇನ್ನ ಇಬ್ರು ಇದ್ದಾರೆ.
For the first respondent, P. Balakrishna.
ಹೌದು, ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
First respondent Shri P. Balakrishna.
I will take out notice on the standing counsel for respondents to.
ಮೊದ್ಲು ಯಾರಿದ್ರು ಅವ್ರಿಗೆ?
ಇವರು ಯಾರು? ಸಾಗರ್.
Learned DSG, Mr. Shanti Bhushan is requested to accept notice for second respondent. Third yaru? P. Prasanna Kumar, learned panel counsel is requested to accept notice for the third respondent. First, review petitioner to serve. Petitioner to serve. Review petitioner to serve copy of the petition along with the documents on the learned DSG and the panel counsel.
Meanwhile, producing this certified copy of this judgment, they are pursuing the another matter. It is posted to 12th, I believe. Let them not precipitate there. That's my request.
There is no error in the order. ಅಲ್ಲ ಅದನ್ನ ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾವು ತಗೊಂಡ್ಬಿಡ್ಬೇಕಾಗ್ತದೆ. ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಡ್ತಾ ಇದೀವಿ ಈಗ. Till then, don't precipitate the matter. In 2 weeks ಅಷ್ಟೇ. The matter under the judgment now put in review shall not be precipitated till next date of hearing. Shall not be precipitated till next date of hearing. First. Yes. All. Yes.
Scene number 9, Shanmukha GC.
Yes, sir.
9 and 10.
When have you changed your name?
ಅಲ್ಲ ಅದು ನಮ್ಮ ಕಲೀಗ್ ಮಲಡ್ ಈ ನಾಟ್ ಇನ್ ಸ್ಟೇಷನ್ 9 and 10.
Time ಬೇಕಾ?
ಟೈಮ್ ಬೇಕು 9 and 10.
ಏನಿಲ್ಲ ಅಂತದ್ದು ಏನು ಮಿಸ್ಟೇಕ್ ನೋಡ್ದೇನೋ ಏನಿಲ್ಲ ಏನು. ಆಲ್ರೈಟ್. ಲಾಸ್ಟ್ ಟೈಮು ಟೈಮ್ ತಗೊಂಡ್ರಿ ನೀವು?
ಅವ್ರೇನೋ
ಹೌದು 27ಗೆ 27 ಜುಲೈದಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡಿರಿ. ಎಷ್ಟು ಸರಿ ಕೊಡ್ಬೇಕು ನಾವು? ಎಲ್ಲ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಕೋತೀವಿ. Call in the second week of January. At the request of, yes. Finally, next. 10 adena?
Scene number 11.
Same order. Yes.
Please, ma'am. Anandishwara.
ಏನಿದು?
Impugned wrongly connected these writ petitions along with the disposal writ petition. I have challenged the acquisition proceedings, my lord, before this honorable court in the writ petition, my lord. But inadvertently, the matter has been clubbed with, this is the disposal writ petitions are come to TDS is.
It's not that case at all.
Please.
There is a mistake on my part. Learned the notice ಆಗಿದೆನೋ?
Service ಆಗಿದೆ sir.
Entry ಮಾಡಿ. ಅಲ್ಲ ಮಾಡಿ.
Meantime, we also issued endorsement.
And additional documents I have produced, madam.
Property unless you got the permission.
Learned counsel appearing for the review petitioner points out the grave error committed by this court in printing the reasoning of some other decision. Not connected to the case. First, this court sincerely regrets its mistake. First, learned counsel appearing for the contesting One is AGA appearing for the first respondent and learned panel counsel appearing for the rest of the respondents. Fairly support the case of petitioner, review petitioner. First off, this is appreciable. Next paragraph. In the above circumstances, the review petition having been favored, the order dated 21/4/2022, whereby WP 21542 of 2021 LBBBMP was disposed of, stands recalled. First off, as a consequence, writ petition stands restored to the board. Restored to the board for being disposed of by the roster bench in accordance with law.
In the additional documents, my lord, the BBMP itself has stated we are not acquired the property. In additional documents have.
ಅದು ಅವ್ರು ಮುಂದೆ ಹೋಗಿ ನಾವು recall ಮಾಡಿದ್ಮೇಲೆ. It is open to the petitioner to press into service the application whereunder leave to put on record the additional documents is fine.
Please.
ಇದು ರಿವ್ಯೂ ಆದ್ಮೇಲೆ ನಾವು ನಡೆಸಬಾರ್ದು. Yes.
Scene number 12, Sarvana.
This petition doesn't survive for consideration. I'm filing a memo, could be disposed.
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಕೊಡಿ. ಇಲ್ಲ ಇಲ್ವಾ?
Next matter.
The review counsel for the review petitioner has moved a memo dated so and so. Short memo dated so and so, which reads as under. Next part. ಅಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು AGA. The AGA who has accepted notice on request for the ಯಾವ respondents? All respondents.
R1 and R2.
R1 and R2 signifies his no objection for the prayer made in the memo. First, in view of the above, the petition is disposed of as having become infructuous.
Yes, seal number 14.
Not very easy. Yes.
Order is 14.
Scene number 13,
Well, yes.
Ji Kulkarni.
Look.
V. Anand.
Tribunal court records are filed where there is an admission that this document is court. I would recall that sale deed is fabricated even before it is registered, the flow of title. I'm referring to the previous title deed. They execute this document as if I have executed. Signature is not mine. And this was not brought to your lordship's notice when the main matter was argued. And your lordship said that this is a matter that has to be decided by revenue court. That no, I request my lord, page 17. I request my lord's kind attention to page 17.
ಈ ಎಂಟ್ರಿ ಮಾಡಿ ಇದೆ ನಿಮ್ಗೆ
ಇದೆ
ಎಂಟ್ರಿ ಮಾಡಿ
Just now I received the memo. Just now I received.
ಅದಕ್ಕೆ entry order to continue call this matter in the third week of January 2025.
ಇದೊಂದು ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಪೇಜ್ 17. ಅದು there's a crucial matter.
ಏನು
he accepts the mistake. ಅದು ನನ್ನ ಭಾಷೆ ಬೇಡ, ಅವ್ರ ಭಾಷೆ ಒಪ್ಪಿದ್ರೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅವ್ರು ಬಂದ್ಮೇಲೆ next date.
This is the fourth time they are absent.
ಅವ್ರು ಈಗ
Government no this between me and government. It is the
third week ನಲ್ಲಿ ಮಾಡೋಣ. ಎಂಟ್ರಿ order to continue.
ಇದು ಒಂದು ನಿಮಿಷ. ಇಲ್ಲ ಅವ್ನ ಹೆಲ್ತ್ ನಾನು ಇಲ್ಲೆಲ್ಲ ಓಡಾಡ್ಕೊಂಡು ಯಾವ ಖಾಲಿ ಜಾಗ ಇದೆ, ಯಾರು ಮಾಲೀಕರು ಬರ್ತಾ ಇಲ್ಲ, ಅದು ಜಾಗ ಹುಡುಕ್ತಾ ಇದೆ, ಇದೊಂದು ಸಿಕ್ತು, ಕೊಡಿ ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಿ ಒಂದು ನಿಮಿಷ. This is the police record.
Page number?
Magistrate ಮುಂದೆ. Page 17, ink page 17. ಇದು statement of the accused.
ಕೇಸ್ ಏನಾಯ್ತು? ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಉದ್ದೇಶಿಸಿಕೊಳ್ಳುತ್ತದೆ ಅಂದ್ರೆ 11/13/2021 ಆರೋಪಿ 2 ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಕಾರಾಗೃಹದಿಂದ ಕರೆದುಕೊಂಡು ಒಂದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿ ದಿನಾಂಕ ತನಿಖೆಗೆ ವಶಕ್ಕೆ ನೀಡುವಂತೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿವೇದಿಸಿಕೊಂಡಿದ್ದು, ಅದರಂತೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಆರೋಪಿಯನ್ನು ತಮ್ಮ ಠಾಣೆಯಲ್ಲಿ ಆಗಿರುವ ಪ್ರಕರಣ ಬಗ್ಗೆ ಮಾಡಿದ ಸಾಲಿನಲ್ಲಿ ನಾನು ಮತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಜಮೀನು ಕಡೆಗೆ ಜಮೀನಿನ ಮಾಲೀಕರು ಬಾರದೇ ಇರುವ ಜಮೀನುಗಳನ್ನು ಹುಡುಕುತ್ತಿದ್ದಾಗ ತಿಪ್ಪಾಪುರದ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊ ಅದು ನೆಕ್ಸ್ಟ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಪ್ಯಾರಾ 2.
No, this is 161 statement.
ಅಲ್ಲ ಇದು ರೆಕಾರ್ಡ್ ಆಗಬೇಕು ಅಂತಾರೆ ಅಷ್ಟೇ. ಇದು ಏನಾಗಿ ಅವರು ಸ್ಟಾಪ್ ಕಮಿಂಗ್ ಟು ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ಇಟ್ಸ್ ಲೈಕ್ ದಿಸ್ ಪಿರಿಯಡ್ ದಿ ರಿಲೀಫ್ sought comes within the framework of the law declared by the Honorable Supreme Court. If the execution is not admitted, if the person is not before the sub-registrar, and if his photo is not there, see, thumb impression is not, then under Article 226 it must be. ಆ ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. Article 2 ತಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಎಂಟ್ರಿ ಮಾಡಿ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿದ್ದೇವೆ ನಿಮ್ಮನ್ನ, ಅವ್ರು ಬರ್ಲಿ. 161 ಅನ್ನ
we are not allowed to use the land. ಅದಕ್ಕೆ 5 ಎಕರೆ 9 ಗುಂಟೆ and ಚಿಕ್ಕಬಳ್ಳಾಪುರದ ಹತ್ರ.
ಬರ್ಕೊಳ್ಳಿ. Learned senior advocate appearing for the petitioners draws attention of the court to the statement
of the accused number
made
2.
by the ಯಾವ respondent.
Accused ಇಲ್ಲ ಅವರಲ್ಲ, accused number 2 ಅದು ಇವರು ಅವ್ರ ಸಾಮಿಲ್ ಗುಂಪು ಲೀಡರ್, ಗ್ರೂಪ್ ಲೀಡರ್ ಇವರು
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. Who executed got the sale deed?
A1 has Bairegowda has executed.
Bairegowda bin Pillappa.
ಅವರು ಬಸವರಾಜು his assistant. Accused number 2. Next page ಒಂದು ನಿಮಿಷ ಓದ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಬಸವರಾಜನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಇದೆ ಕೆಳಗಡೆ
ಬಸವರಾಜ್ A2.
That is
not a party to this proceeding.
Not a party.
Therefore, we cannot act upon it because he is not a party. And number 1, A1, where is the statement of A1?
A1 ಅವರು
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ನೀವು ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. A1 is the executant. That document is executed by A1.
True, my lord.
That what he said before the police is not produced. What A2 is said is produced before us.
ಇದನ್ನ ಮಾಡಿದ ಇದು ಪ್ರಾಡಕ್ಟ್ ತಮ್ಮ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಸಾಹೇಬ್ರೆ.
ಅಲ್ಲ A1 ಅದೆಲ್ಲರ ಇದೆಯಾ? This is A2 ದಿಂದ ಸಂಬಂಧ ಆಗುತ್ತೆ. Firstly, 161 statement is meant for some other purpose. We have seen the judgment of Apex Court in Kathi Raning Rawat versus State of Saurashtra. 5 judge bench decision of the Apex Court. 69 Supreme Court, perhaps if I am right, where they discussed about 161 statement under the old code.
Yes.
Then law is made to the effect that no signature of the person who makes the statement shall be obtained on the statement made to the police. Number 1. Number 2, 161 statement cannot be used for any purpose
except contradiction.
Except for contradicting the version of the witness. Provided he is the person who entered the witness box.
ಇಲ್ಲಿ ನಮಗೆ ಇಲ್ಲ ಇದು ನಾನು ಕೊಟ್ಟಿರೋದನ್ನ
ನೋಡೋಣ ಇರಿ. ಅದೊಂದು ಪ್ರೊಡ್ಯೂಸ್
ಅದು ಮತ್ತು ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬರ್ಲಿ. ಅದು ಅಲ್ಲೇ ನಿಮ್ ಪೊಸಿಷನ್ ಗೆ ತೊಂದ್ರೆ ಮಾಡ್ತಾ ಇದಾರ?
We are not in a position to use the land. We are not in a position. It is developed now. We have converted the land. Wherever 82 lakhs is the conversion fee. We have paid 82 lakhs and we are not in a position to use the land.
Who use the land under what? Is it agricultural land?
Now
what is the kind of
government
nature of?
advocate may help me. It's enclosed by a compound. It has become a safe ground for relief.
Get instruction. I will get instruction.
Instruction partial.
ಅದರಲ್ಲಿ they are producing manure there, human manure.
Call this matter on in the first week of January 2025. ನೀವು ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಅಲ್ಲಿ ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಹೇಳಿದಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ್ರೂ ತೊಗೊಂಡ್ರೆ that will be that may be of some help. We do not
ನಾನು ಅದಕ್ಕೋಸ್ಕರ ಬೈರೇಗೌಡ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೇಕು.
Next.
Scene number 14, adjourned. Scene number 15, Karan Joseph.
Yes, Karan, ಏನಿದು?
Lords, respondent had passed an order seizing certain amounts of 8 crore, my lords. That was challenged before your lordships. During the pendency, my lords, a second seizure order, cyclostyled, was passed, seizing a further amount of 3 crores. My lords were pleased to partially allow the writ petition and permitted us, in respect of the first order, my lords, to use it to pay statutory dues, placing reliance of the decision of the Apex Court in opto circuits. My lords, inadvertently, my lords, the second order, my lords, has been missed out.
Second order is missed out.
Please, my lords. There are 2 seizure orders, my lords. The second one was brought in by amendment
in the judgment, that is not considered.
It's not considered, my lords. Cyclo-styled orders, my lords, only the amounts are different. The application for amendment, my lords, is at page 78, ink page 78, my lords. Filed on 19th July.
Notice ಆಗಿತ್ತಾನೆ ಇದರಲ್ಲಿ?
Please, my lords, smile.
ಆಗಿದೆ.
ಆಗಿದೆ.
ಮತ್ತೇನು ಏನ್ ಹೇಳ್ತೀರಿ ಇದ್ರ ಬಗ್ಗೆ?
This honorable court, my lord.
ಜೋರಾಗಿ ಮಾತಾಡಿದ್ರೆ ಅಷ್ಟೇ ಕೇಳ್ತೇವೆ ನಾವು.
Yes, my lord. The writ petition came to be dismissed on the ground that they have an alternative remedy. Only to a certain extent, my lord, and
If has been granted.
yes, my lord. The what my lords have, the verdict which my lords have given, it won't change even if that particular, the second Caesar order is taken into
So you
consideration.
can go for.
And already,
Yeah, have you availed alternate remedy? The main matter.
Lords, in fact, your lordship said that you cannot say the Great Wall of China and say alternate remedy. And relying on Opto Circuit said, I can't use the money for anything else except for paying statutory dues. And that's what it was used for, my lord. So the second order also, we are asking for the exact same relief. And in fact, my lords, there is also an observation which your lordships have noted that there is no concern of us sending the money anywhere else because we've undertaken not.
No, I will permit you to, you have failed that amendment application in that regard.
the amendment application was filed, my
To
lord.
challenge the second seizure order.
Therefore, what
Please,
we will suggest is, you, we will give liberty to you, instead of considering that application for amendment, you structure your new petition.
My lord,
We will
my-
consider in terms of that.
My lord, may I make one submission, my lord? To the
ಅಲ್ಲ
extent.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪೋಸ್ ಮಾಡ್ತೀರಿ,
No.
ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಹಾಕ್ಲಿಕ್ಕೂ ಅಪೋಸ್ ಮಾಡ್ತೀರಿ. ಈಗ ಇನ್ನೊಂದು ಸಪೋಸ್
Yes, ma'am.
ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ನಲ್ಲಿ ಕೇಳ್ತಾ ಇರೋದು.
Yes, ma'am.
Now, because we have not yet considered in this,
Yes, ma'am.
we are saying,
Yes, ma'am.
there small relief has been, little relief has
Yes,
been granted to him in the light of apex court decision.
Yes, ma'am.
Perhaps that decision was
Auto circuit.
my own judgment which
Was,
went in Supreme
was.
Court, partially to the extent of states, you know. levy-
Utilization of the money.
Ah,
The exchequer, my
To
lord.
the extent of the
Justice
payment of.
Bopanna's
Justice
judgment,
Bopanna,
Justice
please.
Bopanna's judgment.
Bopanna's
Yes,
judgment.
yes.
Yes, I
My
remember.
submission is that, my lord, that the relief, the relief which has been granted to them, to that extent, we have challenged before the division bench, my lord, and that writ appeal is pending.
Okay,
before-
challenge.
Yes, my lord. And he has appeared before that in the division bench also, my lord. It is under consideration.
It's in the office objection stage, my lords, no stay has been granted. And may I also just point out one, in their applications before the honorable division bench, they have asked for details on the entire 12 crores, my lord. So even according to them, it is as if it's the entire 12 crores and not the first seizure order of 8 crores. So even if this were to be reviewed and corrected to that small extent, no prejudice, my lords, perhaps they don't even have to amend it.
ಏನಾಗತ್ತೆ ಅಂತ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ,
Yes, ma'am.
ಅದಾದ್ಮೇಲೆ ಮುಂದೆ ಆರ್ಡರ್
My
ಮಾಡಿ.
lords, there's no stay,
Suppose-
there's,
ಹೌದು, ಮತ್ತೆ ಹಂಗೆ ಆಗತ್ತೆ.
my lords, it was filed, of course, some time ago. It's still in the office
ಅದು
objection
another
stage, my
order,
lords.
another order,
Yes, my lord.
another order which you wanted to challenge by way of amendment.
Please, my
It's a
lords.
fresh cause of action. ಅದ್ರ ಮೇಲೆ ನೀವು separate ಹಾಕೊಳ್ಳಿ.
My lords, may grant,
grant-
give me liberty to file that afresh, my lords.
ಬರ್ಕೊಳ್ಳಿ.
My lord, that particular amendment application was filed before my lords.
Correct.
And that
But
application was.
we did not pass orders on that is his grievance. Where amendment application is made for up to the
With-
pleadings.
May-
It is the duty of the court to pass order this side or that side.
Yes, ma'am.
ಅಲ್ವಾ? ಅದನ್ನ ನಾವು ಮಾಡಿಲ್ಲ.
One indulgence, my lord. I request my lords to kindly take the internal page number 11, page number 21, my lord. That is the operative portion. It will not affect, my lord. The reason is that.
No.
Yes, my lord.
You are under wrong impression.
Yes, my lord.
Amendment is not another ground
Okay, yes, ma'am.
for attacking the order.
Yes, ma'am.
He says the second order is the cyclo-styled version of first order that has been challenged. First order, we have granted some reprieve to him,
Yes, ma'am.
which you have challenged before the division bench.
Yes, my lord.
His grievance is, you have not passed any order on my application. You should have either rejected or allowed, whichever done, I would have done. That contention he is taking, it's right also.
The,
When
because
amendment order.
the reason is that, my lord, that particular Caesar order has already attained finality. The confirmation order has been passed. If he is really aggrieved, my lord, he is supposed to challenge that particular confirmation orders.
ಅದು ಆ ಆರ್ಡರ್ ಕನ್ಫರ್ಮ್ ಆಗಿಬಿಟ್ಟದ ಈಗ.
Yes, my lord.
That,
ಏಟ್ ಆರ್ಡರ್ ಅನ್ನೋದು.
Yes, my lord. The proceedings, what was initiated, it has, the competent authority has passed the order. And my instruction is that, my lord, those proceedings have also been challenged before the Madras High Court by them.
no, my lords.
That is, that.
Lords,
The
the order,
order
please,
which you wanted to challenge by way of amendment
please.
If that order is not in existence because it has merged into another order, then state of UP versus Muhammad Nu comes to their rescue. That order you have to separately challenge.
Please, my lords, that order it's still in existence, my lords, because
How?
the order before the authority in Chennai essentially confirms the order subject to compliance and says that there is further investigation going on, my lords.
Correct. That order is section 8 order.
Oh,
Another.
It is a further investigation. It is
Yeah,
not
Section 37 proceedings, my lord.
37%.
37
The
proceedings.
tribunal.
37A. please.
37A, my lord.
Tribunal.
Yes, my lord.
Then the
So
37.
that is challenged, my lords. May I then submit this, my lords? Lords may give me liberty to challenge this afresh, my lords. My learned friend may take that objection.
Correct. Learned counsel for the review petitioner submits that in the judgment now put in review, comma, nothing is stated about his client's application filed under Article 226, read with Order 6, Rule 17 of CPC, seeking to amend the petition. First off, he adds that the amendment was to lay a challenge to another similar order dated
12/7/2023.
12/7/2023, and therefore review is eminently warranted. First, learned CGC panel counsel,
Panel counsel. my
panel
lord, for the-
counsel appearing for the answering respondents opposes the petition, contending that the said order dated so and so has lost its identity, comma, the same having merged into the order passed by the authority under section 37A,
A.
capital A,
Yes, ma'am.
A of PMLA, another.
Yes, no, my lord. FEMA, my lord.
FEMA.
FEMA.
Of FEMA, and therefore, and because of this development, the review petition is not maintainable itself. First, next one. Having heard the learned counsel for the parties and having perused the petition papers, I am broadly in agreement with the submission made by the learned panel counsel appearing for the authorities. First, it hardly needs to be stated that to review, comma, there has to be an order. This applies to judicial review also. First, since the order which according to the review petitioner had given a cause of action has merged into statutory order under section 37 capital A, comma, there is no order that can be passed, or no, there is no order that can, the subject application now pales into insignificance. And therefore, there is no ground made out for exercise of review jurisdiction.
Lords, may I
First, with the above observations, petition is disposed of, reserving liberty to the petitioner to call in question, to take appropriate proceedings so far as his grievance arising from the order dated
12/7.
12/7.
23.
23. First, in that connection, all contentions are kept open.
Please, lords. Lords, may I file the order, my lords, if necessary? May I file the order, my lords, if necessary?
Order, no,
Please,
that's the only order, no.
please.
Now it has lost identity. I'll work out in view of Muhammad Nu, state of UP versus Muhammad Nu. Yes,
I'm obliged.
no, identity into that, lost its identity. Lost its identity, Ali, wide. Yes,
Scene number 16, Rajesh Patil, P. N. Rajeshwara.
I remember. you pressed into service Justice Bopanna's judgment. They say that the judgment had not considered a part of another decision of the apex. I think it was under 2019, another
2020, indoor development.
indoor development.
They rely on Delhi AirTech case.
Number one. Number two, Mr. Holla said, is already in a proceeding, they have stated that they no longer wanted the land, needed the land. Then to that, Mr. Raghavan said, that was not the correct interpretation of the pleadings. Then you said, if that was not correct, the interpretation, why did you move the court for repairing that? To that level, we stood it. I remember.
Review petition is pending.
Pending.
Notice has been issued.
After, my lord,
So many years.
decades,
My lord,
decades.
there are some 300 respondents in the petition. So now serving all of them has been the notice has been issued by this honorable.
Mr. Raghavan read out one judgment of the apex court which mentioned about urgency. That also meant he called out. So these are the parameters of legal parameters of the case. ಬೇರೆ ಏನಿದೆ argument?
ಬೇರೆ ಅಂದ್ರೆ ಈಗ if the interpretation of Indore is not given by one court, Supreme Court.
Your version is once it is referred to, you cannot say this paragraph of that judgment is not adverted to.
No, in fact, they have considered.
That
Justice
also is
Bopanna, my lord,
considered.
considers the whole thing. He says what was the question there and what is the question here. And then my lord says that is no application. These are the judgments, my lord, which hold.
Senior counsel.
Huh?
Last time learned senior counsel, Mr. Holla had, I think almost finished his argument.
No, I have not started.
Not
If
started.
you have finished it, I'll have to start.
Please, please. No, I'm
Reply.
sorry, I'm sorry.
ಇವತ್ತು ಬಹಳ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಆಗ್ತಾ ಇತ್ತು ನನ್ನ ಕಡೆಯಿಂದ ಇಬ್ರು
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
ನಾನು I wanted to know what.
No,
is the-
naturally. My lord, your doubts will have to be cleared. ಇಲ್ದೇ ಇದ್ರೆ ಹೇಗೆ? Doubts, my lord, that the court has to be, my lord, put forward. And then, my lord, it has to be. These are the line of judgments.
In the Bhagavad Gita, there is one sloka which is on par with what Bible says. Bible says, doubting Thomas withers away. Doubting Thomas
ಗೊತ್ತಾಯ್ತು.
withers away. In Gita, there is similar sloka. Samshayatma pranashyati. Identical, this is in Sanskrit, that is.
ಇಲ್ಲ, in fact, most of the religions, my lord, books.
Speak the same thing.
Ah.
Universal.
Only thing is, my lord, interpretations vary. ನಮಗ್ ಬೇಕಾದಾಗ ನಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡೋದು. ಹ್ಯೂಮನಿಸ್ಟ್ ಆಂಗಲ್ ಇಂದ ಇಲ್ಲ, ಅಷ್ಟೇ ಪ್ರಾಬ್ಲಮ್.
There is one aspect which you have to answer. Before the assistant commissioner, perhaps.
Yes, ma'am. Land acquisition officer.
You say, my grievance is with regard to quantum of compensation.
All that now pales into insignificance because, my lord, all that, they have taken away the money, they have collected the money, they said, we don't want it. At that time, my lord, what I did was, yes, I said, if this is the value that you are giving, all right, that is without prejudice because my writ petition was pending. Yes, there was, my lord, a writ petition pending. Therefore, my lord, it is without prejudice. It can't be, my lord, with prejudice. Matter was pending before your lordships. At that time, I said, my lord, because what happened was, it's a charitable organization. Mahatma Gandhi and Vinoba Bhave, my lord, ashram, my lord, we wanted to set up. Ultimately, my lord, how long should we go on? So we said, all right, if you are giving us compensation, we'll purchase land somewhere else. They, my lord, thereafter didn't come.
ಈ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನು ಇಂಪ್ಯಾಕ್ಟ್ ಇಲ್ವಾ? 39B.
ಅಲ್ಲ, ಇದ್ರದ್ದು ಬರುತ್ತೆ. ಲಾರ್ಡ್ಸ್ ಜಸ್ಟಿಸ್ ದಟ್ ಇದ್ರದ್ದು ಸ್ವಲ್ಪ ಬರುತ್ತೆ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಲಾರ್ಡ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದು ಒಂದಿದೆ. ದಿ earlier judgment, my lord, of division bench, where they, my lord, they have laid down Justice Arvind Kumar and Justice direct ಆಗಿ ಅಲ್ಲಿ ಬೇಕಾದ್ರಲ್ಲ.
ಯಾವ್ದು ಏನು ಪ್ರಪೋಸಿಷನ್ ಹೇಳಿ?
That, my lord, ಈ acquisition ಬಗ್ಗೆ, it must be done immediately. There should not be delay. Compensation must be adequate. ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 5 guidelines had been, my lord, laid down. Narasimha, my lord, Justice Narasimha and Justice Arvind Kumar's judgments
Correct. 7 sutras and hakbutto.
Correct.
They have, my lord, laid down. That also has some bearing on this. All that.
My lord, on the last occasion, your lordships were pleased to note, I'm sorry to interrupt Mr. Holda's argument, that in all of their letters, at no stage they have ever opposed the acquisition as such. Even in the writ filed by them, the first prayer is, please direct them to adhere to the agreement, whereby a certain rate was fixed for the compensation. of the-
Sorry, please look at the prayer. My learned friend is not.
A
correct,
subsequent amendment was made, of course. But that is one of the prayers. Give us the compensation as per that rate.
Please understand, this is a charitable organization started by Mahatma Gandhi. I don't want them, my lord. This was meant for an ashram. And they say, we do not want to, my lord, do this in Srigandha Kaval. Every now and then, my lord, my learned friend will get up. That's a different thing. But then please remember, this is, my lord, meant for a charitable organization. Mahatma Gandhi and Vinoba Bhave must be turning in their grave. Government, my lord, can't. In fact, their argument is, my lord, possession is with them. On an earlier occasion, government, my lord, took over possession from us. If your lordship recollects, my lord, there was an order. I had gone and, my lord, by mistake, my lord, filed a section 66 of the Land Reforms Act, saying that there is, my lord, excess land, though it is a non-agricultural land. Then, my lord,
66 is not applicable at all.
correct. Then, my lord, a writ petition was filed. Writ petition was allowed by this honorable court. What happened was, by the time the Land Acquisition of, my lord, Land Reforms Tribunal passed the order, the very next day, even without copies to us, they took possession of the land. What did they take? Including this from me. This so-called, my lord, they say they are in possession. I place all that before your lordship. That was challenged by the state before the division bench. Dismissed. Challenged before the Supreme Court. Dismissed. Thereafter, my lord, they come and then, my lord, file a review before the Supreme Court. Dismissed. Thereafter, they seek a clarification saying that, my lord, it is with them. Dismissed. ಇಷ್ಟೆಲ್ಲ ಆಗಿದೆ ಅದನ್ನು ಬೇಕಾದ್ರೆ ತಮ್ಮ ಮುಂದೆ ಇಡ್ತೇನೆ. ಅದು ಮಾತ್ರ ಅಲ್ಲ, ಈ ಲೈನ್ ಆಫ್ ಜಡ್ಮೆಂಟ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ನೌ ಗಿವನ್ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಹೋಲ್ಡ್ಸ್ even, my lord, a constitution bench judgment, if it is interpreted, my lord, by a smaller bench, it is a correct. That's, my lord, all these judgments are that. Specifically, they hold. Earlier judgment rendered by a constitution bench, explained in a subsequent judgment rendered by a smaller bench. Then, my lord, it is a smaller bench judgment. All the 5 judgments are that. Therefore, my submission to your lordships is, one, Indore, my lord, their main trump card was Indore. Indore, my lord, is specifically considered by Justice Bopanna. Please have a look at it again.
Yes, I remember.
And, my lord, what was the question that arose? My lord, this is what happened is, the obiter, my lord, is not a binding precedent. They are saying that, my lord, Bopanna's is obiter. It's not Bopanna. Justice Bopanna's is not obiter. Bopanna, my lord, specifically
Refer to that judgment and then.
Not only that, what was the question which arose before him? Please look at, my lord, the question that arose before him. But if my lords take, my lord, the judgment of
Hindu development alva?
Allah,
next follow madiddu. That has been referred to in Justice Bopanna's judgment.
Correct. Please take, my lord, Justice Bopanna's judgment.
Paperwork ittala.
Please come to paragraph 18, my lord. ನಿಮಿಷ ಒಂದು ಮಾರ್ಕ್ ಪೋರ್ಷನ್ ಇತ್ತು, ಒಂದು ನಿಮಿಷ ನನ್ನ ಪೇಲ್ ತೆಗೆದಿದ್ದೀರಿ. ಮತ್ತೆ ನೀವು ಹಾಕಬಹುದು. Please take out your.
Yes. 22 is 2022.
Yes, ma'am.
Come to para 12. On the right hand side now.
Yes.
Almost
Yes, ma'am.
50% of paragraph is over. Then you will read it 80%, etc. That version. Paid before taking possession.
Paragraph 12, my lord.
12 ದಲ್ಲಿ
Correct.
ಅಲ್ಲಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ನೀವು ಹೇಳಿದಾಗ ನಾ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೆ. it would necessarily mean that section 31 will come into play. And the 80% of the estimated compensation amount, though no award is passed, will have to be tendered and paid to the persons interested. If tendered, but not able to pay due, it is to be deposited in section 17 of the
My
short
lord, please come to my lord, the questions, my lord, which was considered by Justice Bopanna at paragraph 8.
paragraph 8.
In the light of the
Three questions are framed in that judgment.
correct. Justice Bopanna's judgment, my lord, three questions are framed. Is the requirement to tender 80% of the estimated compensation contemplated under so and so mandatory to ensure absolute vesting of the notified land? Whether the requirement to pass award within the time frame under section 11A, so and so. Is the case of Surendra Jain, so and so. Then they consider, my lord, Indore, and my lord, they hold. Indore, my lord, was not, my lord, considering this aspect at all. Paragraph 18.
Indur did not consider these questions at all.
Strictly, my lord, it was 24 to my lord, Indore question. Now, please come to my lord, my compilation itself. Iga hakiro compilation.
Indore considered 24/2 of 2013 Acts, right? Correct?
17 irlilla.
Beyond other things, ಏನು ಇರ್ಲಿಲ್ಲ.
And my lord, 18 ಅಲ್ಲಿ, as I was pointing out, Indore, though the learned counsel of the beneficiary place reliance on the question on the decision of Indore, rendered by the Constitution bench, it has been held therein, paid as contained in 24/2, does not include deposit in compensation of compensation in court. We are
of the considered opinion.
we are of the considered opinion that the same will not be applicable to the question under consideration before us in this case. In the instant case, requirement to tender and pay 80% of the estimated compensation and the consequent lapsing as contained above is the context of exercise of urgency provision which permits a deviation from the normal process of acquisition, and the payment envisaged is to take
benefit of the said provision.
In contradiction, the consideration in the cited case, that's Indore.
Effect of 24/2.
That's right.
Not these questions at
Correct.
all.
Correct. And their lordships, my lord, hold that 80%, my lord, is mandatory.
After referring to Satyendra.
Correct. All that. Paragraph 23, their lordships hold.
ನೀವೇನ್ರ ಹೇಳಿಕ್ಕಿದೆಯೇನು?
My lord, ಅದರಲ್ಲಿ
ಬೇರೆ ಏನಾರ ಪಾಯಿಂಟ್ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಹೊಳ್ಳ?
Then, my lord, I had also submitted parents patria, my lord, jurisdiction. In fact, state must, my lord, give us land. ಅದು ಹಾಗಲ್ಲ, ಇದು ಸ್ಟೇಟ್ ತಗೊಳಕ್ ಹೊರಟಿದೆ. For what? I, my lord, purchase this land for the purpose of setting up ashram. I, my lord, went ahead and then, Lord, set up, my lord, many, my lord, activities of mine. There are some lands. Now, they are, my lord, wanting to take over that. Parents patria jurisdiction, my lord, is where, my lord, a charitable organization is involved. Courts always exercise, my lord, parents patria jurisdiction. That's why, my lord, if your lords recollect, in Gujarat, the government wanted to take over some part of the land of Mahatma Gandhi's, my lord, that then, my lord, there was such a furor. They said, no, we are not taking it over. It is in this context. That's why, my lord, if your lordships recollect, I gave your lordships, my lord, 2 judgments of the Honorable Supreme Court itself, where their lordships have held, courts have a parents patria responsibility regarding the religious and charitable trust. ಇದ್ರೊಳಗಡೆ ಸ್ಟೇಟ್ ನಮಗೆ ಲ್ಯಾಂಡ್ ಕೊಡ್ಬೇಕು, ಅದಲ್ಲ ನಿಮ್ಮನ್ನೆಲ್ಲ ಇಟ್ಕೊಂಡು ನಾವು ಇದು ಮಾಡ್ತೀವಿ. That can't happen. And
any decisions of any high court, because I have not come across, where doctrine of parent patria is treated in acquisition proceedings.
I'll try and give that.
My lords, I crave 10 minutes time because my learned senior Mr. Raghav will answer a few of the questions.
ಇವ್ರೇನ್ ಹೇಳೋದು ಹೇಳಿ. ಅದಾದ್ಮೇಲೆ ನೀವು ಕೊಡೋಣ ಸರ್.
6-1, my lord, if a 6-1 notification is issued after 1 year, then, my lord, the acquisition lapses under section 11A. ಅದು 2 judgment ಹಾಕಿದ್ದೇನೆ ನನ್ನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟೇ ಹಾಕಿದ್ದೀನಿ.
My lord, I'm sorry
As-
again for to
ಇರಿ
interrupt.
ಒಂದ್
Yes.
ನಿಮಿಷ ಮುಗಿಸ್ಲಿ. ನೀವು ಕೂತ್ಕೊಳ್ಳಿ, ನಿಮ್ಗೆ ಹೇರ್ ಏನೋ anxiety ಇರ್ಲಿ, ವಿಲ್ ನಾಟ್ ಪಾಸ್ ಎನಿ ಆರ್ಡರ್ಸ್. Anyway, this is a very heavy matter where I have to, perhaps I have to work during my.
On this judgment,
I
because
have to-
your lordship is reading the judgment, I just wanted to bring your lordship's kind notice to para 17 of the very same Delhi Airtech judgment,
17.
17. Because your lordship is on that point, that is why.
ಇದು ಐ ಆಮ್ ರಿಮೈಂಡೆಡ್ ಆಫ್ ಮೈ ಲಾರ್ಡ್ ದ ಶಟಲ್ ಕಾಕ್ ಕೋರ್ಟ್. ಅಲ್ಲಿಂದ ಒಂದು ಬಾಲ್ ಹಾಕುತ್ತೆ, ಇನ್ನೊಂದು ಬಾಲ್, ಇನ್ನೊಂದು ಬಾಲ್ ಹಾಕುತ್ತೆ, ಮತ್ತೊಂದು ಬಾಲ್. ಅಟ್ ದಿಸ್ ರೇಟ್ ನಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ದಿಸ್ ಇಸ್ ಅ ಕೋರ್ಟ್ ಆಫ್ ಲಾ. ದೇರ್ ಇಸ್ ದ ಪ್ರೊಸೀಜರ್. ಇದು ರಿಪ್ಲೈ. When they, my lord, got up, I did not even open my mouth. Why? Because there is a courtesy required. There is a methodology of doing it. ಇದು ಹಾಗಲ್ಲ every now and then, my lord. ಇದು
You were reading the decision.
My lord, let me read, my lord, 17 itself, my lord, para 17. My learned friend wants me to read, my lord, want your lordships to read 17. Let me read 17. Please look at 16 first. But it's a different matter altogether, para 16.
When section
the-
17 one is invoked.
Invoke.
Requirement
The
thereof.
requirement thereunder
Which condition is not complied.
complied. As noted, subsection 3A has been inserted with effect from 24/9/1984, whereunder it is made mandatory to tender and pay 80% of the estimated compensation before taking possession. Therefore, even if possession is taken, such possession cannot be considered as legal so as to vest the land absolutely if the prerequisite condition for payment of 80% before taking possession is not complied. In such circumstances, by legal fiction, it loses its character as an acquisition under section 17. And since the absolute vesting does not take place, it will lapse if the further process is not completed and the award is not passed within 2 years from the date of declaration. However, even when the precondition is not complied, if the landlorder does not challenge the acquisition and or taking possession as illegal, but concedes the possession taken does not become per se illegal and the vesting will become absolute. In such an event, it cannot be considered to have lapsed until the landlorder exercises the right. We consider it so, since both section 11A and 3A of section 17 of 1984 Act were inserted in the 1894 Act were inserted in the Act of 1894 to enable the landlords to exercise their right conferred on them. As such, said right is to be exercised by the landlorder and none other. That's okay. That's but a subsequent purchaser can't. Not even the acquiring authority or the beneficiary, nor would these provision become automatically applicable unless it is triggered by the landlorder. Therefore, we are of the considered view that section 11A, though applicable to the cases of acquisition initiated under section 17, consequence of it will not affect the case where the land has absolutely vested on compliance of section 3A of section 3, the subsection 3A of section 7. Andre 3A of 17 80% ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ 11A my lord becomes ಆಗುದಿಲ್ಲ. ಇದರಲ್ಲಿ 80% ಡೆಪಾಸಿಟ್ ಮಾಡಲಿಲ್ಲ admittedly. Compliance of subsection 3 of section 17 of that and 80% of the compensation is tendered or paid. When there is a challenge by the landlorder, each case will have to be considered on its own merits to determine whether the prerequisite condition to tender and pay as contemplated in the subsection 3 is made before possession is taken. If in the case concerned, mandatory prerequisite is not complied, such acquisition will lose its character as being under section 17. And if the award is not passed within 2 years from the date of declaration, it will lapse and not otherwise.
Sorry,
The benefit.
that one line, my lord, that one line I wish to emphasize.
One second.
And if the award is
My lord,
passed with
a single, my lord, a single
true.
swallow,
You
single
cannot-
swallow doesn't make a summer. My lord, will have the
You are-
benefit of the said provision
the benefit of said provision
is available only to be invoked by the landlorder
and cannot
and
be invoked
cannot be invoked by the acquiring authority.
to claim lapse
Ah.
by pointing to
Non-compliance
Since the vice of non-compliance cannot
be permitted to be converted to a
into
virtue. Then 18, though the learned counsel for the beneficiary placed reliance on the decision of Indore Development Authority versus Manohar Lal, that is, my lord, Indore 2020,
You have read it.
rendered by the so and so.
You have read it.
Yes. Therefore, my lord, my submission to your lordships is, this considers, my lord, the decision. Now, my lord, please look at the other compilation I given to your lordships today. Please have a look at it. First judgment. Please come to, my lord, paragraph 16.
Page.
ಬಂದೆ. Page, my lord, running page. ಕೊಡ್ತೀನಿ. ತಡೀರಿ, ಮಾಡ್ಕೊಡ್ತೀನಿ. 15.
115. This court here.
After this court thereafter had considered the decision of UP Avas Ivam ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಎಲ್ಲ ಒಟ್ಟಿ ಸೇರಿಸ್ಬಿಟ್ಟು ನೀವು ಇದು ಮಾಡಿ. And Himalaya tiles and marbles, and has distinguished the same, and has observed and held that the decision UP Avas Ivam Vikas Parishad and Himalaya tiles and marble shall not be applicable in respect of the acquisition under KIDB Act of 1966. Once this court, in a subsequent decision in Pirappa Hanumappa Harijan, dealt with and considered the earlier decision in UP Avas Ivam Vikas Parishad and Himalayan tiles and marble, distinguished the same, and observed and held that with respect to the acquisition of the KIDB Act 1966.
This is for your argument that they cannot contend that particular decision is not considered, etc. Once it is interpreted, that becomes the law.
That's right. Because those judgments of UP Avas Ivam is a larger bench judgment. Pirappa Malad is a two-judge bench judgment of the Supreme Court.
Yes.
Last sentence ತಾವು ನೋಡಿದ್ರೆ para 16 ಅಲ್ಲಿ last sentence next page ಅಲ್ಲಿ page 16 ಗೆ ಬನ್ನಿ. Last 4 lines of above para 17.
Article 140, not following the binding precedent.
In the earlier decision, considered and distinguished by this court. Subsequent decision, the court is binding upon the High Court and not the earlier decisions, which are distinguished by this court. My lord, this is reiterated. This is, my lord, 2022. Please come to, my lord, page 17. Adaralli paragraph 38 ಗೆ ಬನ್ನಿ. At running page 34.
It may be.
By way of almost, my lord, 38, my lord, yes. One other judgment in Master Cables Limited, Private Limited versus State of Kerala is seen at this stage. The section concerned in section 90 so on so fell for consideration in this case also. It was declared in para 10 in unequal terms. My lord, I'll skip all this. In paragraph 11, this court observed in Master Cables, my lord, like this. Once this court had noticed observations made in Hiralal case, then narrowed the width of the observation expressed in para 27 thereof. We must proceed
in terms of the subsequent
That's right.
judgment.
There the earlier judgment was taken note of. Then, more important is, my lord, Justice Jeevan Reddy, sitting, my lord, in a full bench, of course, Allahabad, my lord, High Court. Justice Jeevan Reddy, my lord, as the Chief Justice of Allahabad High Court. Please come to page 36. Adaralli this is
PP
Yes, my lord.
Jeevan Reddy.
1991 SEC Online Allahabad 939. Adaralli paragraph 16 at, my lord, running page 44. This is a full bench judgment of the Allahabad High Court. My lords, get that, my lord, at running page
Para
16 at page 44.
particular reliance.
Reliance was placed upon certain observations of Ramchand Kailash Kumar Supra, which in a general way tend to support the petitioner's argument. We do not think it necessary to set out the said observation because in a subsequent judgment of the Supreme Court in Srinivasa General Traders versus State of AP, 1983 4 SCC 5353, these very observations have been explicitly referred to and explained as not laying down the legal principle of general application. Faced with these observations in Srinivasa General Traders, learned counsel for the petitioner took the stand that inasmuch as Ramchand,
it is not a case of inconsistency between the judgments of the
Correct.
Supreme Court.
correct, in which the
In which
cases,
the different rules apply.
correct,
It is a case where an earlier judgment, no doubt rendered by a constitutional bench, is explained in a subsequent
Subsequent.
judgment. Therefore, they cannot contend that Hindu development
That's
has
right.
not considered.
that's right,
This is your version.
correct.
Okay.
Then, my lord, another judgment of the Calcutta High Court, my lord, at page 49. Idralli, paragraph, my lord, internal page, my lord, 4. Unnumbered paragraph 1 ಅಲ್ಲಿ ತಾವು ಬಂದ್ರೆ
Page number?
sorry, my lord, 1 minute. ಅದು very lengthy, my lord, judgment. Please come to my lord page 52. ಅದರಲ್ಲಿ please come to my lord third unnumbered para. In the case before us anta barutte.
Yes.
The
Subsequent
subsequent decision,
decision of
smaller
similar
bench
bench in the
has
case of-
taken note of the earlier decision in the case of so and so and has interpreted the same. And thus it is not the view taken by the tribunal cannot be said to be wrong and is inconsistent with the taken in Azadi Bachao Andolan case.
Correct.
To a similar effect, my lord, is last
So
judgment.
it is considered and rendered.
Correct.
Therefore, law
That's
as
right.
declared by the subsequent judgment has to be followed. Is
Correct. In fact, my lord, as I pointed out, full bench of the Allahabad High Court rendered by His Lordship Justice Jeevan Reddy specifically says even a constitution bench judgment. In fact,
Interpreted by the High
my
Court.
lords are aware, my lord. I mean, I didn't want to unnecessarily burden your lordships with authorities and authorities. The judgment, my lord, in that Manipal Foundation case with regard to education has subsequently, my lord, interpreted, my lord, in smaller judgment. All, my lord,
Smaller judgment becomes the law.
correct.
Because it is construed that. way.
Correct, correct. Therefore, in though, my lord, in this case, my lord, admittedly 80% not deposited. In this case, my lord, having, my lord, not deposited the amount, my submission to your lordship says the entire thing, my lord, goes. And not only that, now please look at it from another angle. My lord, how many years earlier, my lord, was this notification issued? According to them, my lord, there's some urgency. Section 70, my lord, adu judgment alla ನಾನು ಹಿಂದೆ ಹೇಳಿದ್ದೇನೆ, ಇದು ಇಲ್ಲಿ ರಿಪಿಟೇಷನ್ ಆಗುತ್ತೆ. Urgency ಇರಬೇಕು. If you keep quiet, don't issue anything. And my lord, can there be urgency? And third is, they, my lord, go and then say, ಇಲ್ಲಿ ನಾವು ಮಾಡೋದಿಲ್ಲ, ಬೇರೆ ಕಡೆ ಮಾಡ್ತೀವಿ. Now, my lord, they file a review after several decades. My lord, that itself shows that there is something, my lord, cooking, which is not, my lord, in the interest of, my lord, our body polity. After all, this was a ashram meant for, my lord, Mahatma Gandhi and Vinoba Bhave's, my lord, ideals to be propagated, and we are doing it. Therefore, my submission is that, my lord, these are the aspects, my lord.
ಈಗ ಪೊಸಿಷನ್ ಯಾರಿದ್ದಾರೆ?
ನಾವೇ ಇದ್ದೀವಿ.
ನೀವೇ ಇದೆ.
What has happened is, I must tell your lordships. Now, Supreme 66 ಆಗಿ contempt ಹಾಕಿದ್ವಿ. Contempt ಹಾಕಿದಾಗ, it has been going on for the last, my lord, 3 years. They permit, my lord, encroachments, left, right and center.
By others.
ಹೌದು. ಆಮೇಲೆ ನಾವು ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಇವತ್ತು ನಾನೀಗ ನಾಳೆನೆ ಕರೆಸಿ ಈಗ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತೀನಿ ಅಂದ್ಮೇಲೆ 279 ಎಕರೆ ಕೊಟ್ಟರು, 95 ಎಕರೆ ಸ್ಟಿಲ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಆ ಕಡೆ ಈ ಕಡೆ permission, my lord, everybody is coming and encroaching. Now police complaint ಕೊಡ್ತೀವಿ. In fact, there are several interim orders passed by the single judge, division bench, by the contempt court. ಇದೇ ತರ ಆಗ್ತಾ ಇದೆ. In fact, that's why I pointed out. According to them, my lord, they are in possession of this land. In, my lord, that judgment of learned single judge, which is affirmed by the Supreme Court, review dismiss, my lord, clarification dismiss. Specifically, my lord, they take possession from us of the entire 400, my lord, nearly about the 300 odd acres, including, my lord, this land, my lord, which they are now claiming, my lord, is to be acquired for them. That is directed to be handed over to us. ಅದರಲ್ಲಿ ಇಂಪ್ಲೀಟಿಂಗ್ ಹಾಕೊಂಡು ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇದರಲ್ಲಿ ಇದೆ, ಅದರಲ್ಲಿ ಇದೆ. ಎನಿವೆ.
Yes.
So, Learned Senior Counsel, Mr. Raghavan will reply.
ಯಾವತ್ತು ಮಾಡ್ತೀರಿ?
Any time next week, any date next week.
Before the memory fades.
Any date. I have asked him for his schedule.
Before my memory fades.
Any date next week.
ಯಾವ ಡೇಟ್ ಹೇಳಿ? ಆ ಡೇಟಿಗೆ ಆಡ್ ಮಾಡಿ. ಮತ್ ನಾ ಮರ್ತು ಬಿಡಬಾರ್ದು ಅಂತ. ಏನಾಗ್ತದೆ, ದಿವಸ ನಾವು ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತೇವಲ್ಲ, ಅದ್ರಲ್ಲಿ ಎಲ್ಲೆಲ್ಲೋ ಒಂದ್ ಕಡೆ
Tuesday, Tuesday ಇವರು ಇರಲ್ವಂತೆ.
May I request for an ear? Now the
Thursday.
there are 2 petitions, my lord.
ಇನ್ನೊಂದು, my lord, there is a companion petition, ಅದರದ್ದು ನಾವು ಮಾಡಿಲ್ಲ,
ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ಹೌದು.
Lord, because the first comes acquisition of 171 acres.
Correct.
Thereafter, the 100 acres is invoked under the urgency clause. Therefore, your lordship will also have to consider
That also.
because it has a link.
ಹಾಗಾದ್ರೆ ಅದನ್ನ ಹೊರಡ್ರು ಮಾಡ್ಲಿ, ಅದನ್ನ ಇನ್ನೊಂದು.
That also Learned Senior Counsel only has to
complete arguments on that also, my lord. And then thereafter,
Don't mind, no
we'll
problem.
give a comprehensive reply to
ನೋ
both.
ಪ್ರಾಬ್ಲಮ್. ಅಲ್ಲ, ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ರಿಪ್ಲೈ ನಾನು ಮಾಡಿ, ಅವ್ರು ಮಾಡಿ, ಎಲ್ಲ ಮಾಡಿ, ನಂದು ರಿಪ್ಲೈ ಬಂದಾಗ ಈಗ ನಾವು again they want to reply, all right, doesn't matter. I don't want to, my lord, say anything.
ನಿಮ್ಮ ಇದ್ರ ಪಿಟಿಷನ್ ಯಾವತ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹೇಳಿ.
ಹೇಳಿ ತಮಗೆ ಯಾವತ್ತ
ನಮ್ಗೆ ನಾವು ದಿವಸ ಇಲ್ಲಿ ಬರ್ಲೇಬೇಕು.
ಅಲ್ಲ ತಾವು
ನಮ್ಗೆ
ಸಿಂಗಲ್ ಅಲ್ಲ
whichever
ತಾವು
date you
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ತೀರಿ, ಸಿಂಗಲ್ ಬರ್ಬೇಕಂತ ಅಷ್ಟೇ. ಇಲ್ಲದೆ ಇದ್ರೆ my lord
Friday, my lord, if it's convenient.
Huh?
Next Friday, if it's convenient to the court.
23rd ಸಿಟ್ಟಿಂಗ್ ಡೇ ಇದೆ,
ಆಗ್ಬೋದು.
ಸ್ಯಾಟರ್ಡೆ.
23rd my lord.
ಬರ್ಬೋದಾ?
ಆಯ್ತು.
ಅಲ್ಲ ಹೇಳಿ, ಬೇರೆ ಡೇಟ್
ಇಲ್ಲ ಬರ್ತೀನಿ 23rd ಬರ್ತೀನಿ.
My lords, for all of us, it's a learning experience to be with Mr. Holla. He's like my
Always.
guru. Looking at
He
him, I have learned so much.
He's like that, no? His father was my guru. BP Holla. 10 Hollas will be 1 BP Holla. This is your mind. ಏನ್ ನೋಟ್ಸ್ ಎಷ್ಟು ವರ್ಕ್. ಮತ್ತೆ 23rd ಹಾಕೊಳ್ತೀವಿ.
ಪ್ಲೀಸ್
23rd.
Number 17, T. Seshgiri Rao.
ಇನ್ನೂ ಇದಾವ?
Your lords, this matter, the stay order on the arrest, your lords.
Huh?
There's a stay order on the arrest,
Huh.
due to which I'm unable to take any kind of maintenance or any kind of award which was earlier passed. It is a maintenance case, domestic violence, 125.
You are for the
I'm for the wife and the child, your lords.
wife.
Yes, your lords.
He's under arrest and detention now.
Yes, and it was released subsequently on this writ petition.
Huh. Release from part. ನಂಗೆ ನೆನಪೇ ಇಲ್ಲ ಇದು ಏನು ಅಂತ. Yes.
Interim.
Interim or to continue.
And your lords, a date may be fixed before.
ಒಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಡೇಟ್ ಬರಲ್ಲ, ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಥವಾ 2 weeks ಇಂದ.
Yes, your
Call
lords,
after
because I've
2
been
weeks.
moving memo here.
Okay. Interim or to continue till next date of hearing. Yes.
Number 18, Sunil Kumar S.
This code of as having been withdrawn, ಏನ್ ಸುನಿಲ್ withdraw ಮಾಡ್ತಾ ಇದ್ದೀನೋ?
Yes, ma'am.
ಬರ್ಕೊಳ್ಳಿ. Petitioner has filed a memo dated so and so seeking leave of the court to withdraw the petition. First of memo reads as under next paragraph. Learned AGA appearing for the respondent has no objection for grant of leave. First of, in view of the above, petition is disposed of as having been withdrawn in terms of memo.
Much.
For 19, for final hearing, Pawan Kumar.
My lords, this
Special
matter.
order.
The split verdict, my lords, and then my lords.
ಅದು ನೋಡಿಲ್ಲ ಅದನ್ನ.
A very
Divergent opinion.
very interesting point on the Coal Mining Act,
Okay.
the interpretation of the word prior allotee.
Prior approval.
Prior allotee, who is a prior allotee?
The prior allotment.
ಅಷ್ಟೇ. Who has to bear that liability? Honorable Supreme Court said, they struck down all the coal allocations. They said for the past, they said 295 rupees per ton you have to pay. Now, where it's a 10,000 crore liability.
Who should pay?
Who should pay?
That depends
Whether
upon
it
who
is
is
the-
the prior allotee.
Yes.
A law ಹೇಳೋದು prior allotee should pay ಅಂತಿದ್ಯಾ?
ಹೌದು.
ಹಂಗಾಗಿ who is the prior
Prior
allotee should be.
So the dispute is whether the joint venture between the private company and the state corporation, whether that is to pay or the state corporation. For example, in respect of Karnataka, whether it is the Karnataka Power Corporation or another entity created jointly by Karnataka Power Corporation with a private interest.
Okay.
Lordship Justice Dinesh Kumar held that it is that private entity which has to pay,
Not KPC.
not KPC. Justice Subrakamal Mukherjee held that it is only KPC which has to, not the private entity. Which is why it is before your lordship.
ನಾನು ಇನ್ನೂ ಓದಿಲ್ಲ ಅದನ್ನ ಎರಡನ್ನು.
Interesting.
ಬರ್ತೇನೆ next.
Interesting.
Like Shanti Bhushan sir had appeared for petition and,
Why Shanti Bhushan?
ಅಲ್ಲಲ್ಲ.
no, for petitioner,
No.
late Shanti,
ಅಲ್ಲಲ್ಲ.
it was,
No, the original
Blessing-
Shanti Bhushan, not our days.
so for the petitioner, the Shanti Bhushan, it was a blessing for us to even hear him argue.
I gave Shanti Bhushan's autobiography.
Second innings.
No. Courting justice. ನಾನು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್
Minutes, if I may request, after 4 weeks, one date.
4 weeks.
We need to search for a senior advocate.
ತಮ್ಮ ಹತ್ರನೇ ಆದ್ರೆ ಒಳ್ಳೇದು.
ಅಲ್ಲ ಇಲ್ಲೇ ಆಗತ್ತೆ. There's a special order. There's no other way around it.
2 weeks ನಲ್ಲಿ ಮಾಡಿ.
Yeah, I will.
ಅಷ್ಟ್ರಲ್ಲಿ ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀನಿ. ಕರ್ಕೊಂಡು ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಪಾಯಿಂಟ್, ಬಟ್ ಮೆನಿ ಇಂಪ್ಲಿಕೇಶನ್ಸ್ ಆರ್ ವೆರಿ ವೆರಿ ಹ್ಯೂಜ್. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks. ಎಸ್. ಯಾವ ಬೇರೆ ಹೈಕೋರ್ಟ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿಲ್ವಾ ದ ವರ್ಡ್ priority, the term priority?
We'll find out.
Nodi,
We'll
just-
place it before Lordship. Not since, Lord,
ನಮ್ಮ
the other side also has
research-
to engage some senior, if a date is fixed, it will benefit. ಅವರು ಯಾರೋ, they will have to bring some senior.
Another
right.
contribution.
Correct. ನೋಡಿ.
Last week of November, my lord, if you are.
ಹಾ.
Twenty-eighth or 29th.
28 DP ಇರ್ತದೆ. 28 ಮಧ್ಯಾಹ್ನ ಹಾಕೊಳ್ಬೋದಾ?
Very well.
ಹಾ. 29th. ಸರಿ. 29th
Okay,
ಆರ್ಗ್ಯೂ ಮಾಡಿ.
29th.
Okay? Yes, thank you.
Till number 20, M. Shiva Prakash.
ಇದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್.
My lord, pray for short accommodation.
ಎಲ್ಲಿ ಶಿವ ಎಲ್ಲಿದ್ದಾರೆ? ಇಲ್ಲಿ ಕೆಳಗಿದೆ. ಸ್ಪೆಷಲ್. ಹೌದಾ? As per special order dated. Post the before case. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂತ ಬೇರೆ ಕಡೆ ಹೋಗಲ್ಲ, ನಾವೇ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಆಲ್ ರೈಟ್. ಏನು?
Short accommodation, is not feeling well.
ನಾಟ್ ರೆಡಿ?
No.
ಆಫ್ಟರ್ 2 weeks ಅಂತ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಏನು? ಇಲ್ಲ.
ಇಲ್ಲ.
ಆಫ್ಟರ್ 2 weeks. ಓಕೆ.
Lordship kindly,
ಹಾ.
morning Lordship, while allowing the writ petition Lordship in the serial number 14, directed the government to appoint within 2 months. We have no objection.
Appoint, give effect to the order of the tribunal.
Please Lordship, we have no objection as such, Your Lordship. Problem is, Your Lordship, they have to send the selective selection list to the government. Thereafter, we have to verify whether she has the experience or not. It's only thereafter we can issue appointment order.
So 2 weeks will not be, 4 weeks shall not be.
ಆಗೋದಿಲ್ಲ, ಅವರಿಗೂ ಡೈರೆಕ್ಷನ್ ಬೇಕು, ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ಕೊಟ್ಟು ಆಮೇಲೆ ನಾವು ರಿಸೀವ್ ಮಾಡಿ ಅದನ್ನ ವೆರಿಫೈ ಮಾಡಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಡ್ತೀವಿ.
ಅಲ್ಲ, ಇಬ್ಬರಿಗೂ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ಟೇವ್ ನಾವು. Both to give effect.
ಅಲ್ಲ, in view of division bench order
of 8 weeks ಅಂತ ಹೇಳಿದ್ದೇವೆ ನಾವು.
ಇನ್ನೊಂದೇನಾದ್ರೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸ್ವಾಮಿ, ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ವೆರಿಫೈ ಇಟ್.
ಮಾಡಿ.
DC ಮಾಡಬೇಕು.
ಅಲ್ಲ,
Whether she has that criteria, whether she meets or not, that we have to verify before issuing. ಅದಕ್ಕೆ in accordance with law ಅಂತ ಮಾಡ್ಬಿಟ್ರೆ.
ಅದರಲ್ಲ?
ಹೌದು ಸರ್. ಅದಕ್ಕೆ
14
14 serial number 14.
14 ಯಾವುದು ಅಂತ open ಹೇಳ್ರಿ.
Selection list ಕೊಟ್ಟು Lords.
ಗೊತ್ತಾ ಸತೀಶ್ ಅಂದು?
ಹೌದು. We have no objection for appointment, Lords, because there is a direction. That's serial number 2 my lord.
ಅದು ಹೊಡ್ಕೊಂಡು ಅಷ್ಟು ಮಾಡ್ಕೊ. 14 ನಲ್ಲಿ 8 weeks ನಾವು ಕೊಟ್ಟೇವಲ್ಲ.
Serial number 2.
In accordance with law ಅಂತ.
In serial number 2, disposal matter.
ಹಾ.
Compliance memo.
Compliance memo, all right.
Highly obliged.
All. ಅಣ್ಣ?
ಬೆಳಿಗ್ಗೆದಾಗಿತ್ತು. ಅದನ್ನ ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ, ಯಾರು ಕಮ್ರೋಸ್ಮಾನ್ ಸರ್ ಹೇಳಿ ಸರ್, ಯಾವ್ದ್ರಲ್ಲ ಇದು? ಮೇಡಮ್ ಹೇಳ್ಬಿಡಿ, ಮೇಡಮ್ ಕೆಟ್ಟದ್ದು ಬರ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. 14 ಅಲ್ಲಿ TPC ಆಗಿದೆ ಮೇಡಮ್.
The government has to consider in accordance with law within 2 months. Sent to the government. ಅಲ್ವಾ? ಹಾಗೆ ತಾನೆ? Sent to the government. And the state government comply with the orders in accordance with law.
KPS ಅವ್ರು ಕಳಿಸ್ಬೇಕು ಅಷ್ಟೇ ಸೆಲೆಕ್ಷನ್. ಮೇಡಮ್ ಇದೊಂದು ತಗೊಂಡು ಒಂದು ನಿಮಿಷ ನಿಮಗೆ ಕಳಿಸ್ಬಿಡಿ ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲ ಫೈಲ್ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ದೆನ್ ನೋ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಬಂದ್ಬಿಟ್ರೆ ಅದು ಸೀಲ್ ನಂಬರ್ 2 ಬರ್ತಿದೆ. ಸೀಲ್ ನಂಬರ್ 2 ಇದೆ ನೋಡಿ ಸರ್. 2, 3 ಎರಡು ಡಿಸ್ಪೋಸಲ್ ಸರ್. 2, 3 ಎರಡು ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿರೋದು ಅಲ್ಲ, ಈಗ ಮತ್ತೆ ಅದು ಕ್ಲೋಸ್ ಅಲ್ಲ. ಇಲ್ಲ 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 ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಬರೀ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಷ್ಟೇ. ಅದು ಡೇಟ್ ಏನು ಅರ್ಜೆ ಕೊಟ್ಟಿಲ್ಲ, ಏನಿದೆ ಕ್ಲೋಸ್ ಆದಂಗೆ ಕ್ಲೋಸ್ ಆದ. ಮೇಡಮ್ ಹೋಗಿ ಬನ್ನಿ ಮೇಡಮ್. ಎಲ್ಲ ಹೋಗ್ತೀರಾ? ಆರಾಮ್ ಕೂತ್ಕೊಳ್ಳಿ. ಕೇಸ್ ಯಾಕೆ ತಂದು ಕೂಡ್ಸಿ ನಿಮ್ಗೆ ಏನು ಕೆಲಸ ಕೊಡ್ತೀರಾ? ನಾವೆಲ್ಲ ಮಾಡ್ಬಿಟ್ಟದ ಮೇಡಮ್. ತಗೊಂಡ್ಬಿಡಿ ಅದು ಬೇರೆ ಇಟ್ಕೊಳ್ಳಿ ಸಪ್ರೇಟ್. ಅಪ್ಲೋಡಿಂಗ್ ಇದು ತೊಗೊಳ್ಳಿ, ಅಪ್ಲೋಡಿಂಗ್ ಏನೋ ಬೇಕಂತ ತಗೊಂಡು ಅಷ್ಟು ತಗೊಂಡು ಮಿಕ್ಕಿ ನಾನು ಬರ್ಕೊಡ್ತೀನಿ. ಯಾವುದು 8 8 6 4 8 6 ಆಮೇಲೆ 4 ಓಕೆ ಟೈಪ್ ಮಾಡಕ್ಕೆ. ಮೇಡಮ್ KLR ಬ್ರಾಂಚ್ ಒಂದು ಫೋನ್ ಮಾಡಿ ಮೇಡಮ್. KLR ಬ್ರಾಂಚ್ 802. ಹಾ ಅಲ್ಲ ಡೇಟ್ ಇದೆ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿ ಇದೆ? ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಎಲ್ಲಿದೆ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್? ನೋಡಿ ಮತ್ತೆ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ಸುಮ್ಮನೆ ಸಾಹೇಬ್ರು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂದ್ಕೊಂಡಿದ್ದಾರೆ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇದನ್ನು ಹಾಕ್ಬೋದು.
ಯಾವ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಏನು ಇಲ್ಲ.
ಈಗ ಒಂದು ಫೋನ್ ಮಾಡಿ 802 ಮಾಡಿ.
$1920
ಅದೇ ಇಲ್ಲ, ಇಲ್ಲಿ ಸೀಲ್ ಇರ್ಬೇಕು. ಸೀಲೇ ಇಲ್ಲ ಅದು.
serial number 1 ಏನಾಗಿದೆ
ಹೇಳಿ ಸರ್.
serial number 1 ಸರ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್
ಸೀಲ್ ನಂಬರ್
1
ಬೆಂಚ್
RFA 1920.
ಅಲ್ಲೋ ಆಯ್ತು ಸರ್, ಅಯ್ಯ ಅಲ್ಲೋ ಆಯ್ತು ಅದ್ರ ಮೇಲೆ.
ಅಯ್ಯ ಅಲ್ವಾ ಆಗಿದೆ. ಥ್ಯಾಂಕ್ ಯು.
ನಮ್ಮ ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಇವತ್ತು ಏನ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. ಎಸ್ ರಾಜಶೇಖರ್ ಆದ್ಮೇಲೆ ರೈಟ್ ಸೈಡ್. ಏನು ಯಾರು ನೀವ್ ಹೇಳಿ, ಯಾರು ಏನು
ರಾಜಶೇಖರೇನಾ? ಬೇರೆಯವ್ರ ಹೆಸರಿಲ್ಲ,
ಬಿಡಿದ್ದಾರೆ.
ಹಾಕಿಲ್ಲ.
ಇಬ್ರು ಇದಾರೆ, ಲಿಂಗರಾಜ್ ಅಂತ ಇದಾರೆ, ಅಂಶುಮಂತ ಅಂತ ಅಂಶುಮನ್ ಅಂತ ನೋಡಿ, ಅವ್ರನ್ನೆಲ್ಲ ಬಿಟ್ಟೇ ಬಿಟ್ಟಿದ್ದಾರೆ. ಏನ್ ಮಾಡೋಣ ಈ ಒಂದೊಂದ್ಗೆ. ಮೆಮೊ ಕೊಡಿ ಒಂದು. ಗೋವಿಂದ, ಸೀಲ್ ನಂಬರ್ 20 ಬೈ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂತ ಹಾಕಿದ್ದೀರಾ. ಎಲ್ಲಿದೆ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್? ಇದೆ ನೋಡ್ದೆ, ಇರ್ಲಿಲ್ಲ. ಇವಾಗ ನಾನು ನೋಡ್ದೆ, ಕೇಸ್ ವರ್ಕರ್ನು ಕರೆಸಿದೆ ಅಲ್ಲೇ ಬಿಡಿ KLR ಇಂದ. ನೋಡ್ದಪ್ಪ, ನೀನ್ ಬಂದು ತೋರ್ಸಪ್ಪ ಇದು ಬೇಗ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಡೈರೆಕ್ಷನ್ ತಗೊಂಡಿರ್ಬೋದು. ಇದು ಬರ್ಲಿ ಬಿಡಿ ಸರ್, ಬರಕ್ ಹೇಳಿದಿರಾ, ಬರ್ಲಿ ಬರ್ಲಿ ನಮ್ಗೆ ಕ್ಲಾಸ್ ಆಗುತ್ತೆ.
ಸೀಲ್ ಬೇಕು, ಸೀಲ್ ಇರ್ಬೇಕು, ಸೀಲ್ ನಿಂತ್ಕೊಡು. ಇದು ನೀವು ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಹೊರಟರು ಈ ತರ ಪುಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ ಸೀಲ್ ಇದ್ಮೇಲಿಂದ ಸೀಲ್ ಇಲ್ಲ ಅದೇನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡ್ರಿ ಅದು 20 ಸಿನಿಮಾ 20 ಏನು ಏನ್ ಬರ್ದೆ ನಾನೇ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಬರ್ದಿದ್ದೇನೆ ಏನು ಯಾವ ಹೋಯ್ತು ಇದು 2 weeks ಆಯ್ತಾ 2 weeks ಆಯ್ತಲ್ಲ ಸಿಂಬ 17 ಅದು ಜಿಎಂ ಎಫ್ಸಿಬಿ ಯಾವ ಟೈಮ್ ಮಾಡ್ತಾರೆ ಹಿಂಗೆ ಕೊಟ್ಬಿಡ್ತಾರೆ ಈ ಡೇಟ್ ಬೇಕು ನಮ್ಗೆ ಸ್ಪೆಷಲ್ ಡೇಟ್ ಬೇಕು ನಂಗೆ ಅಟ್ಲೀಸ್ಟ್ ಇದು ಕಾಣಿಸ್ಕೊಂಡ್ರೆ ಮಾಡ್ಬೋದು ಅಂತ ಅದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ ಮಾಧುರಿ ನೀವು ಅಷ್ಟು ದೂರದಿಂದ ಬಂದಿದ್ದೀರಾ ಯಾರಲ್ಲಿ ಮ್ಯಾಂಗ ಮಿಲ್ಕ್ ಹಾಕೋ ಬನ್ನಿ ಯಾರಲ್ಲಿ ಮ್ಯಾಂಗೋ ಮಿಲ್ಕ್ ಶೇಕ್ ತಗೊಂಬನ್ನಿ ಇಲ್ಲಿ ಹಾ ಮ್ಯಾಂಗೋ ಮಿಲ್ಕ್ ಶೇಕ್ ತಗೊಂಬನ್ರಿ ಮೂರು ನಾವೆಲ್ಲ ಫುಲ್ ಅಪ್ಡೇಟೆಡ್ ಆಗ್ಬಿಡ್ತೀವಿ ಯಾವ್ದು ಪೆಂಡೆನ್ಸಿ ಇಡಲ್ಲ ನಾನೀಗ ಅದೇ ಕಾಫಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ಮೇಡಮ್ ಹೋಗಿ ಬಸ್ಸಿಗೆ ಹೋಗ್ರ ಯಾವ್ದಿದೆ ಸೊ ಇದು ಬರ್ದೆ ನೋಡಿ ಇದೊಂದು ತಗೊಳ್ಳಿ ಬಸ್ ಇದು KL ಅದೇ ಅದೇ ಬರ್ಬೇಕು ಅದು ಹಂಗೆ ಇಡಿ ಕೈಲಿ ಹಿಡಿದ ಹಾ ನೋಡಿ ಎಂತ ಧರ್ಮ ಸಂಕಟದಲ್ಲಿ ಸಿಗಿಸ್ತಾರೆ ನಮ್ಮನ್ನ ಹಾ ಎಂತ ಧರ್ಮ ಸಂಕಟದಲ್ಲಿ ಸಿಗಿಸ್ತೀರ
ಆ ಕಡೆ ಪಾರ್ಟ್ನರ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸ್ಟ್ರಾ ಬರೆಯೋಣ ತೆಗೆದುಕೊಂಡು
ನಮ್ದೇನ್ ಮಾಡಿದೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಎಲ್ಲಿ ಬಸ್ಸು ಅರೇಂಜ್ ಕಮ್ಮತ್ ಬಂದಿದ್ರು ರೈತರು ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಹೇಳಿದ್ರ ಏನ್ ತೊಂದ್ರೆ ಇದು ನೀವೇ ಅಂತ ಬರ್ಬೇಕು ಏನ್ ಬರ್ತೀನಿ ಏನ್ ಬರ್ತೀನಿ ಏನ್ ಬೇಕಿತ್ತು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಇದೇ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಬರ್ದಿಲ್ಲ ಇದೆ ಏಯ್ ಇನ್ನ ತಿಂತಾರ ಸಿಕ್ಸ್ಬೇಡ ಏನ್ ಹೇಳಿ ಏನ್ ಏನ್ ಹೇಳ ಏನಪ್ಪ ಇದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 13/10 ಎಲ್ಲಿ 13/10 ಆರ್ಡರ್ ಇಲ್ಲಿ 13/10 ಅಂತಂದ್ರೆ ನಮ್ಮ ಹತ್ರ ಇರ್ತದೆ ಕಪ್ಪಿ ಅದು ಅಂತ ತೋರಿಸ್ಲಾ ಯಾವ ಕಾಲದಲ್ಲಿ ಬರ್ದಿದ್ದು ಇದು ನಮ್ಮ ಮುಂದೆ ಏನಕ್ಕೆ ಬಂತು ಹೇಳಪ್ಪ ಕೇಳಾರ ಆಯ್ತು ಒಂದ್ಸತಿನೂ ನಮ್ಗೆ ಬಂದಿಲ್ಲ ಆಯ್ತು ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಏನಕ್ಕಂತ ಹೇಳ್ತೀನಿ ತಾಳಿ ಇದ್ರ ಬಗ್ಗೆ ನಾನು ನೋಡಿದೆ ಒಂದ್ಸತಿನೂ ನಮ್ಮ ಸಾಹೇಬ್ರ ಮುಂದೆ ಬಂದಿಲ್ಲ ಆಯ್ತು ಇದೊಂದು ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಏನಕ್ಕಂತ ಹೇಳ್ತೀನಿ ಆಯ್ತು ಒಂದು ಬಿಟ್ಬಿಡಿ ಬೆಳಗ್ಗೆ ಅರ್ಜನ್ ಆಗಿದೆ ನೋಡು ಏನ್ ನಾನು ಹುಡುಕ್ದೆ ಇವಾಗ ನೀವು ಬೇರೆ ಸೀಲ್ ಹೊಡೆದಿರ್ತೀರ 13 ವರ್ಷಕ್ಕೆ ಅದು ಓಕೆ ಈಗ ನಾನು ಬರ್ದಿಲ್ಲ ಅದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಫೋಟೋ ಇಟ್ಕೊಂಡು ಯಾರು ಕೇಳ್ಕೊಳ್ಳೋದು ಯಾಕಂದ್ರೆ ನಾನು ಅವಾಗ ಬೋರ್ಡ್ ಬಂದು ಇರ್ಲಿಲ್ಲ ನಾನು ಪರ ಸುಮಾರು ಐತೆ ಮೋಸ ಇಲ್ಲ ಒಂದು 10 ಒಂದು 5 ಬೀಳ್ತಾಗ್ತೇನೆ ಅದೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿಲ್ಲ ತಾನೆ ಅದು ಏನಿಲ್ಲ ಕೇಳ್ಬಿಟ್ಟು ನಮ್ಮ ಮುಂದೆ ಎಷ್ಟು ಏನು ಅಷ್ಟೇ ಈ ನಂಬರ್ ಇಂದ ಈ ನಂಬರ್ ಎಂಡ್ ಆಯ್ತು ಏನು ಯಾರಿಗೆ ಯಾರು ಅಂತ ಬರ್ದಿಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಅಷ್ಟೇ ಅವರಲ್ವಾ ನೀನು ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಹೇಳಿದ್ದೀನಿ ಫೋನ್ ಮಾಡ್ತೀನಿ ಏ ಸರಿ ಕಾಲ್ ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಆನ್ ಸ್ಪೀಕರ್
Get free Hello Tune. Press star and 9 to install Wink Music app. The person you're calling is not answering. Please try later. ನೀವು ಕರೆ ಮಾಡುತ್ತಿರುವ ವ್ಯಕ್ತಿಯು ನಿಮ್ಮ ಕರೆಯನ್ನು ಉತ್ತರಿಸುತ್ತಿಲ್ಲ. ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ಪ್ರಯತ್ನಿಸಿ. आप जिस व्यक्ति को कॉल कर रहे हैं वो उत्तर नहीं दे रहा है. कृपया कुछ समय पश्चात प्रयास करें.
SNB को ಸೋಮಶೇಖರ್ ಎರಡನೇ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ 2025 ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ 2025 ಏನಿಲ್ಲ ಬರೀ ಡೇಟ್ ಕೊಟ್ಟು ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ 2025 ಪರವಾಗಿಲ್ವಾ ಓಕೆ ಥ್ಯಾಂಕ್ಸ್ ಅಣ್ಣ ನೀನು ಒಳ್ಳೆ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡೆ ಏನು ನೋಡಿ ಎಲ್ಲ ರಿಲೀಸು ಏನೇನ್ ಬೇಕು ಸಬ್ರಿಜಿಸ್ಟರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಒಂದ್ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಯ್ತು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡವ್ರು ಡಿಸ್ಮಿಸ್ ಆಗೋಯ್ತು ಅದಕ್ಕೆ ದುಡ್ಡು ತಗೊಂಡಿದ್ರು ಪಿಜಿ ಯಾರಾಗಿದ್ರಾಗ ಪಿಜಿ ಯಾರಾಗಿದ್ರು ಪಿಜಿ ಯಾರಾಗಿದ್ರಾಗ ಕರೆಕ್ಟ್. ಅವ್ನು ಅವಾಗ ಬೇಜಾನ್ ತಿಂತಾ ಇದ್ದ. ಬೇಜಾನ್ ದುಡ್ಡು ಮಾಡಿದ್ರು.